Welcome, ladies and gentlemen of our audience. Thank you for attending the second of two sessions a week apart. This is Thursday, November 21st, 2024, and we're going to be here for quite a long time, 3 hours, to discuss follow-up issues from last week's introductory session on independent experts working primarily as country conditions experts, but also sometimes clinicians, doctors, psychiatrists, and people with really esoteric, recondite expertise that apply to a specific client in an unusual situation. And this week, we're going to shift our focus more from the nuts and bolts and how to write a declaration or how to testify to some of the more technical issues of testimony in a defensive proceeding in immigration court. We're also going to spend the first hour primarily discussing relations between the lawyers and the experts. Most of the people in the audience are going to be focused as social scientists on trying to figure out what this is all about, or if you've had some experience getting into the more advanced points. We encourage people in the audience to raise questions by writing them to me, and I'll read them. In general, we have 15-minute sessions where the speaker will speak for about 10 minutes, and then we'll have discussion, if any, from the panelists, but focus primarily on answering questions from the audience. So feel free to just write them in the message link in the Zoom tab below. And we are going to start today with Michelle Devereaux, who is from a nonprofit NGO, non-government organization that sponsors specific work in her case, and she'll tell you what their expertise is, but primarily the African diaspora, and people have some link to Africa. And we also have Monica Khan, who's here, and will speak second, and we'll talk about the Georgia Asylum and Immigration Network, where she was the founding director and presided for about a decade or longer over that organization. And the two of you should feel free to talk to each other. So we have two types of NGOs to start off. And what I'd ask you both to focus on is what was your organization's mission? What did you look for in an expert? How were the experts able to operate given the rush circumstances that some cases present, particularly relevant to going forward with the prospect of at least expedited removals of people where you need overnight action to get a stay from an immigration judge or someplace like that. And if you want to speak a little bit about looking forward to the Trump administration in a general kind of way, not revealing any proprietary information, but just how you're thinking about the inevitable change in mission with many more people in detention or immediately scheduled for removal, etc. So we'll start with Michelle. Could you just say a few words about your background and then proceed to your organization?
Yeah, hi everybody. As Chip said, my name is Michelle. I work at an organization called African Advocacy Network. We're based in San Francisco, and it was started in 2009. And it really is for the purpose of serving the African and Afro-Caribbean communities. We do offer affirmative and defensive legal services. For me, I primarily work in removal proceedings, in immigration court, and my clients are generally seeking asylum as a defense to removal. There are some things that are unique to San Francisco in the immigration context, and I'm not sure if you want me to talk about.
Sure, just briefly.
Okay. Sure. So,
especially the sanctuary city issue, because
exactly,
President-elect Trump has announced that he wants to seek to ban sanctuary cities.
Yes, he does. It's something that is unique to San Francisco and a few other cities across the country, but essentially what that means is that the city does not actively work and collaborate or use city funds to assist ICE in raids and other
Could you
actions.
just say for the first time, Immigration and Customs Enforcement, because the audience.
Oh, I'm sorry. Immigration and Customs Enforcement, which we call ICE. And so that does provide a layer of protection to immigrants in the city. Something that we also have that's unique in San Francisco and does kind of touch upon looking forward to or anticipating the Trump administration is we have a 24-hour rapid response network. It is a collaborative effort from different immigration nonprofits in the city. And we provide 24-hour access to a phone number for emergency immigration services. It's staffed by different attorneys, including myself and different organizations in the city. And we do receive some funding from the city to help support that. I do apologize for any construction noise if you guys hear that in the background. The joys of apartment living. One other thing that is also unique to San Francisco that you touched upon is expedited judicial dockets in immigration court. So we are one of 10 cities that has a dedicated docket, which was put into place in 2021 by the Department of Homeland Security, DHS, and the Department of Justice, DOJ. And it focuses on providing expedited processing for family units in immigration court. They kind of framed it as a humanitarian effort. But speaking from experience, I would say it actually does the opposite. And it poses a number of challenges and raises some due process concerns because we're meant to have each case fully processed in 300 days, which if you're at all familiar with the multi-year long timeline of most immigration cases, it really, to have it fully adjudicated within less than a year is such an abbreviated timeline. And that does really affect our ability to work with expert witnesses. I've worked with probably 4 or 5 families on the dedicated docket so far. And it has been a challenge to find expert witnesses who are available and able to turn a report out that quickly. Because most times we're given about 3 months to prep a case when the judge actually sets a hearing on the calendar. It's about a 3-month turnaround. So it's something that, as I mentioned, raises due process concerns for, you know, how I am able to zealously and fully prepare my client's case and present their case in full when we have hindrances and resource challenges as well.
Do you ever put an expert on without a declaration just because of the time constraints?
I've personally never done that. I don't know that I would feel comfortable. I think best practice is to submit the report and work with the witness beforehand, the expert, to you know, anticipate what kind of testimony is needed, if any. Because a lot of times in immigration court, to my experience anyway, I haven't had to voir dire an expert during the hearing. Most times the credentials are stipulated and the contents of the report are stipulated to by the government attorney as well.
I only mention that because I've been called a couple of times, not very often, of
Oh,
course.
wow.
And
I don't know about Monica.
back in the day, unlike contemporary years, but in going back 10 to 25 years ago, ICE, and it was called INS initially, was much more accommodating. I was never challenged my qualifications. Now, it's, as I'll speak later today, it's almost automatic. So you could get someone at the, I mean, there had to be a reason, and the reason would be because this case was scheduled 36 hours or 72 hours before for actual defensive proceeding. Do you want to talk a little bit about the types of clients and what makes them different and how you interact with them as an organization before we introduce Monica?
Yeah, I work with, as I mentioned, the African and Afro-Caribbean communities in the Bay Area. And this is a community of people that are typically underrepresented, underserved, and frankly misunderstood in immigration proceedings, and criminal proceedings as well. I want to highlight that people from this demographic particularly benefit, in my experience, from working with expert witnesses who can provide a country condition report. This is because a lot of the judges that I've presented a case in front of, a lot of times my client from Haiti, Senegal, Cameroon, whichever country, that's the first time that that judge is encountering a respondent originating from that country. And it poses challenges, but also an opportunity to kind of set the tone, and give the judge a first impression of that cultural and historical landscape. So kind of having an independent, qualified expert provide an objective report full of on-the-ground insight or years of, research-backed expertise really solidifies whatever open source country conditions I've been able to provide on my own. If time permitting, I can give a quick example of a case where
Go
I
ahead.
really found it to be crucial. I had a family on the dedicated docket, so that expedited judicial track. And I was in a rush to find a witness, an expert, I'm sorry, who was able to turn out a report on that timeline. This family had a unique situation that was family-based claim and religious-based. And it involved two primary religions in their home country. And one person converted to the other to be in a marriage. And it angered both sides of the family. Really, really violent threats and actions were taken from both parties. And when I was doing open source research, human rights reports, academic reports, news articles, overwhelmingly said both of these religions coexist peacefully. The national law in the country is, you have freedom of religion, but that wasn't the reality. And I was able to find an expert who had on the ground expertise, who was able to say, that might be what the government says is happening, but this is what's actually happening. And because I was able to have that report and not able to substantiate it independently with my own research, the judge really pointed to that in his oral decision, the expert's report, as being a really key piece of evidence. A really key piece of evidence in granting their asylum case, fortunately. So I wanted to give you an example of a case where I feel like it really kind of turned the tide in my client's favor, to highlight the importance of, working collaboratively with nonprofit attorneys.
Thanks, Michelle. Before I turn it over to Monica, let me just ask one last question. The NGO model of looking for clients allows you to be very selective in a number of ways. I mean, maybe in your way, you might be looking for someone who's aware of any racial implications of the case, and you develop expertise like that. And secondly, more generally, I know in Monica's case, Gain in Georgia would often go to the large scale hearings to look for the most obvious candidates for asylum. And I've often felt that the NGOs actually, if they could get clients for those people and then focus on the next tier down, because they don't get the lawyers yet because the docket is so large and the NGO capacity to find lawyers or to have staff attorneys to address that one tier down of people who've been politically persecuted but fled for their life because so they have no documentation because it was too dangerous to go home. I mean, that would be one example of many where they're strong on the merits, but they don't have the evidence. So they're a good chance for denial. And those people often don't get lawyers because, or some analogous situation like that. So Michelle, why don't you answer that particular question, and then Monica, I'll ask you to introduce yourself and then pick up describing Gaines' mission and contrast it, let's say, from Michelle's organization.
Yeah, I can really only speak to our org, and we don't actively seek out our potential clients. We have a really strong word of mouth community in the African and Afro-Caribbean diaspora here in the Bay Area. It's actually the opposite, where we are at the point where we're fully at capacity and we have to, unfortunately turn people away who need help. But all of our services are pro bono for immigration court. And so I think when you're referring to, clients that don't have as strong of evidence, we don't take we don't make merit-based decision cases. I'm sorry, we don't take cases based on their merits. So that's not how we decide. And so we run an intake process, and we try to be as diplomatic as we can when we decide which cases to take based on capacity.
Thanks very much, Michelle. And Monica, would you introduce yourself?
Yes, just getting off mute. Hi, everyone. Can you hear me?
Yes.
Okay, great. Thank you. So yeah, my name is Monica Kant, and currently I'm the CEO of the Asian Pacific Institute on Gender-Based Violence, which is a national nonprofit that is a resource center and works with all AAPI organizations that work with survivors of violence, and we provide resources and tools and trainings and do policy advocacy nationally with Congress on the AAPI community and survivors of gender-based violence. But that is not why I'm here with you today. I'm here with you because Professor Chip had met me. We had met probably 15 years ago when I was at the Georgia Asylum and Immigration Network, where we had founded, the law firms in Georgia, in Atlanta had founded the organization, but I was their first staff member to really take that pro bono project and facilitate pairing asylum cases where we would do the screening, but pairing them with pro bono attorneys from the law firms in Atlanta and training and mentoring the attorneys while they would represent the cases in immigration court. In Atlanta, 15 years ago, we were the first organization of our kind in Atlanta. So it was a really delicate process to get that organization going. I am by practice an immigration attorney. I started doing this work in 1998 in New Jersey and only represented asylum cases that were detained at the Elizabeth Detention Center. So when folks would declare for asylum at Newark Airport or JFK Airport, they would be transported to Elizabeth Detention Center. And so my background is in representing asylum cases. And when Gaines started in 2006, I was able to utilize that knowledge and background to really get this project started in Atlanta. Up until then, we had, organizations like Catholic Charities Latin American Association providing direct services, but we were the first of our kind to incorporate pro bono attorneys from the law firms to not only have the manpower to represent asylum seekers and victims of crime, but also really get the message across about immigration and asylum seekers across Atlanta. I remember when I started in 2006 in Atlanta, folks said to me, gosh, I didn't even realize immigrants needed legal representation. To now, 15 years later, there are other organizations like Kind and Tahare, national organizations that have opened up offices in Atlanta, because the need is so great, and the message of the need being great is important here in Atlanta. So, a lot of what Michelle, had mentioned about experts rings true to what we have done too. I think there's such a big part, important part of the case. And, what we had, in Atlanta was maybe a more conservative immigration system. I had come from working in New Jersey and then later Boston. And let me tell you, it was a very different environment. Things like clinics where you could discuss merits of the cases were, possible there, or we had a direct, line to the immigration courts where we could do clinics even on immigration court, site. We didn't have that accessibility in Atlanta. We had more conservative judges who, just wanted to get cases out and moving. We knew that certain cases would be very difficult. Like, for example, in 2010 or in the mid 2000s, we knew that gang cases from Central America were not going to be really strong cases here in Atlanta. So we would have to measure and evaluate, the resources that we could provide, because that same case might be approved in, San Francisco. And so we just would have to, kind of work within the system that we had and see if there was a better jurisdiction that the case could go to, if it was not detained. Do you have family in San Francisco? Maybe you should move there. I mean, we wouldn't overtly say jurisdiction shop, but that was kind of, in a way, what we would, tell clients where their cases could be a little bit more amenable. In Atlanta, we had a 2% asylum case grant rate, where, and when I came from Boston, it was close to 40%. So you can just see what we were working with. And the fact that we could have pro bono cases, from, attorneys who had no idea that the system was this difficult here in Georgia, really elevated the issue and made sure that others cared about it as well.
Thank you, Monica. Can you say a little bit of word about the fact that Gaines also worked on gender-based violence, and
Absolutely.
just because and how that came about and when you it was, etc.
Yeah, so we began immediately when Gaines started in 2006 working on asylum cases. That's what we were founded for. It was one of the law firms had gotten a phone call and said, who does pro bono asylum cases in Atlanta? And, and it was from their fellow office in Washington, D.C., where there was a robust program, or many programs in D.C. doing pro bono asylum cases. And, the law firm Alston and Bird, who had received that call, had answered no one. And they said, well, you should probably think of establishing something. And that's how Gain started. It was just a law firm to law firm idea. And then more law firms became involved and began the seed funding for it. And then we were able to get outside funding. But in 2008, we also realized that this type of pro bono representation wasn't available for trafficking cases, domestic violence cases, U visa cases, VAWA cases, other immigrant cases that really needed humanitarian type of, legal representation. And once we could show the success for asylum cases of getting attorneys involved, to get attorneys involved in trafficking cases, which just happened to be one of those key issues in Atlanta around 2010 because of the Super Bowl coming, we were able to utilize that energy and start a similar victims of violence program to our asylum program, around 2008, 2009. And the, interest and the attraction of those cases to, even a larger pool of pro bono attorneys like Delta and Coca-Cola attorneys became even more, robust, because those cases were cases that others, that maybe asylum cases, because of the difficulty that Michelle explained about, they really weren't as, interested in doing those cases. But filing an application that would go to an office and you could help, a survivor that wasn't detained was something that, really, exploded in a good way here in Atlanta. So our Victims of Violence program, just from the get-go, took off, and it still is one of the programs that Gain houses that has a lot of interest.
Thanks so much. One last question before we turn it over to Alexis Ruiz. Um, can you explain the incentives and the problems of trying to get a asylum application on the basis of someone being trafficked and the legal provision for cooperating with the prosecutors, which puts a kind of dilemma. We're offering you asylum, but you're going to risk your life potentially if you turn in some gangster who's
Yeah.
willing. Can you talk a little bit about that, please?
Yeah, so after 1996, there was a huge change in immigration law, IRA, and I started practicing in 1998, so that's all I've known. But especially after 9/11, everything became, a lot of immigration band-aids became very enforcement based, and the U visa, the T visa is part of that, where if you are able to help law enforcement, then they'll go ahead and sign a certification that will assist in applying. Now, they're not signing a certification to give you the visa, but that certification is proof that you have helped law enforcement in their investigation, prosecution of the crime. And, it really is like an I scratch your back, you scratch my back visa type of thing, but it puts immigrants in a really, really dangerous position, Chip, as you mentioned, because the folks that are out to get them either here or who have connections in their home country are still there. And so that is puts our clients in a very difficult predicament. Already our clients are not coming into our offices wanting to work with law enforcement, and with this new administration I see a similar reaction happening all over again because they're afraid of deportation. And, if there is something that now may, let the world know that this is, what they're, number one, the shame, even before you get to, gosh, the perpetrators might be there in their home country waiting for them, and they've given, information on that. But just the shame in revealing what's happened, the family now needing to know, and then the next step of other outside parties who are dangerous, doesn't help a client. It is not client centered in order to work that way, in order to heal the client who has already been through so much trauma. And it puts an added responsibility and obligation to this whole system. So it's just not a great way to proceed. But I want to say I see with our new administration a lot of similar actions happening, even more so in a very focused and pointed way.
Could you get a social group legal basis for asylum if they didn't want to go the route of the trafficking cooperative person?
Right. So, gosh, are you asking for the definition of asylum?
No, just
Oh.
simply if you chose not to put your client through working with the prosecutors to turn in the person who trafficked them and
Mm.
that PTSD involved, can you still have some good luck, good results just applying for traditional asylum through the typically weakest legal basis, which is social?
That's what I was going to say. It's probably, going to be a lot harder if, they're not going to go the route of working with law enforcement, applying for asylum. It is possible, but I would look at the jurisdiction. I would look at the judges. I wouldn't do it here in Atlanta because of the judges that we have that are more conservative and with the 2% grant rate. But if you're in a jurisdiction where that it would be dependent upon the judge and the jurisdiction that I would even go forward with that.
And
And that's like last option.
Michelle, San Francisco is in the most highest approval rate in the country. Would your thinking about this be different? Going the trafficking route, or that's just too humiliating for the potential client, or you just don't know yet, case by case?
That's not sure. Yeah, everything is so case specific. And I do primarily work in court, so I haven't had a lot of experience with T visas. I've worked on a couple U visas, but I would fully
Why don't you
defer
say
to
a word
Monica.
about what U visas are?
Huh?
Why don't you say a word about what U visas are? Because
Sure.
I want the audience to know all the abbreviations.
Oh, I'm sorry. So a U visa is a special visa that is something available to victims of crime in the United States, and it has to be a certain qualifying crime. And those are enumerated by USCIS. And in addition to that, it involves getting a certification from law enforcement, cooperation from the victim of the crime to certify that crime. And it is an administrative process through USCIS, but it is an option.
Well, thank you both so much. You're welcome to stay and remain or go. And we're very grateful for your very clear explanations. And Alexis Ruiz has been very patient and will give the view from a private immigration law firm, Zambrano and Ruiz, which you founded recent years, 2 to 3 years ago, I think. 5, oh, excuse me. So would you just say a little bit about your firm, but also compare it with the nonprofit model and the pressures that you have and the clients that you have? They sound like you have a much broader base of clients in some senses, but in most cases, you have to make a living and pay the overhead. So, Alexis, over to you.
Sure thing. So we have been in business for a little over 5 years, and we see a broad array of clientele. So we don't just use or request the help of expert witnesses for asylum cases. We also have asked them for some provisional unlawful presence waivers, for deferred actions for kids with medical conditions or adults with medical conditions. But it's all sort of coming from the same database. And I did create a worksheet with which Kat just shared with everyone. It's very basic. I basically, I wrote it for individuals who don't have experience being experts before, but I explained first how private attorneys find expert witnesses, what we look for when we're hiring expert witnesses, and what we expect after the retention of an expert witness. And immigration attorneys are very communal. We share a lot of resources. I'm not going to say we don't compete, but I think it's less competitive than a lot of other fields of law. So we do share resources, and referrals is probably one of the more common ways for us to get expert witnesses. We also call upon expert witnesses who we've worked with before. But then there is I'm not sure if anyone has talked about the CGRS database yet.
No, feel free.
Okay, so UC Law San Francisco, which I'm sure Michelle could speak more on UC Law San Francisco, but they have a database that's generated and maintained by the Center for Gender and Refugee Studies. And it's on the worksheet, a link to it. You can click you make a profile first, and then there's a tab that says experts. And you can either find an expert there or register yourself as an expert. And there are hundreds of experts, and everyone uploads their CVs, and you can read through people's experience. And you can also categorize yourself as a medical expert or a country conditions expert. And you can even subcategorize yourself as a specific topic of expertise, like LGBTQ issues or military police service. So it's very organized, and it's easier for us because we have specific issues that we have to present to silo the expert that we need and to target. So the way that I approach finding one is I go onto this database and I narrow it down to maybe 10 to 12 people, and I email everyone. And surprisingly, maybe 20% of people get back to me. And then I share what my deadline is and explain a little bit about what my case is about and what I'm looking for. And then I come up with a few options and present these options to my clients, who are ultimately going to foot the bill. So my clients usually want my input. So I look at resumes. It's very important for resumes to be updated. I know you touched on this a little bit earlier, Chip. But it's surprising how much the judges are going to rely on your expertise, and how soon it's been since you obtained your experience. Like if you did a Fulbright if you did a Fulbright program in Peru 40 years ago, and I have a case that I'm working on in Peru right now, it's probably not going to be as relevant, the work that you did 40 years ago. It's very important to stay up to date and to make sure that there's a way to demonstrate your knowledge.
And that's because it's current country conditions that is really at work, because especially in Atlanta, judges are apt to say, well, we got a new government, and everything's different.
Oh yeah, for sure. They will deny for every reason possible. And especially now with this new administration coming, we know that less of our cases are going to be dismissed. Currently, we're able to have conversations with the other side of the aisle, with the trial attorneys, with the Department of Homeland Security, asking for them to dismiss proceedings for clients who aren't priorities for deportation. So if there are people who have pending asylum applications who I see are probably going to lose on nexus, or there isn't a very strong claim, and I know we're moving towards, you were on
Sorry,
mute.
could you say what nexus means?
Sure, it's when you draw the connection between the reason, the protected group, so whether they were persecuted for their religion or for their nationality or race, and the reason behind the persecution. So whether you can draw this legal connection, if you can't make the legal connection for the judge, then most likely your client isn't going to win, and then they end up with a voluntary departure order or a deportation order, and that's what we're trying to avoid at all costs. So if you know that you're going that way, we ask for them to dismiss proceedings, which is something that's available during the Biden administration. During the first Trump administration, it wasn't. So we had to take all these cases all the way to the merits, which is most likely what's going to happen in Trump 2.0. So we really have to right now, we're going to need a lot of support and help from experts right now, because a lot of these cases are going to be taken to trial.
Okay, and finally, could you say a few words about the number and the range of types of cases that you take in a specialized immigration private law firm, and maybe compare and contrast it what you heard from our two NGO clinical
Sure. Yeah,
organizations?
so we take a lot of family-based cases. We take waiver hardship cases, so you're able to petition for family members, but a lot of times your family members entered unlawfully, so you have to request for the government to waive their inadmissibility, which they could be determined to be inadmissible to be lawful permanent residents because they have accrued too much unlawful presence in the United States. So we're basically asking the government to forgive this ground of inadmissibility based on humanitarian grounds. And one of the things that we usually touch on is the current conditions of the client that the person would be removed to. So I did recently retain an expert for a waiver, for a Mexican waiver. And we received a request for evidence on this waiver, and the request for evidence wanted to know specifically how the person was living in their current in Tampico, actually, which happened to have experienced droughts and a hurricane. So, I mean, unluckily for the client, but luckily for our expert, they had a lot to work with, because the situation in Tampico wasn't great. So that waiver got approved, and it was a large part because of the help of an expert witness.
And how many cases does your firm do you have? How many attorneys do you have and support per people?
There's 2 of us attorneys, and we have 8 support staff, and we probably, I don't know, active cases, I mean, hundreds. I really don't know how many at any point, because they take forever to get adjudicated, but maybe 500 per person.
And how many of these cases are short-term, scheduled, medium-term, and let's say more than 2 or 3 years into the future for removal?
I just received a text message actually from a WhatsApp group that I'm on that says Atlanta is now scheduling master calendar hearings within 3 to 4, individuals within 3 to 4 months. I think I'm averaging about 2 to 3 per month. individual hearings, which are merits-based hearings. But I think that's the least amount of cases that we have. Most of ours are the long-term family-based cases, probably, well, maybe 50% of them are long-term family-based cases. Maybe 20 to 30% are active court cases. And then the minority are the ones that are moving quickly, like dedicated docket cases.
And two last questions. The first is, have you ever worked with NGOs? In other words, the NGOs have the connections for these big law firms. And from the point of view of an expert, sometimes, I have sort of three types of situations. And when I'm working for a big law firm, they get all the guns and whistles out and they have almost unlimited resources. My very first case 25 years ago, they sent independent analysts to Afghanistan to look at the village where there's bombed, to document that when the client says it was bombed, you can see that it's bombed. And they hired someone from Human Rights Watch. I mean, that was sort of like the supreme. And some private law firms have sent me to Haiti to collect information. And it's very, very powerful, but that's so much the exception that proves the rule, that even those with legal representation, are still in Atlanta facing long odds. So have you, first of all, teamed up with any other organizations to basically combine the resources? And if the answer is no, and I assume it is, what kind of situation do you have for your clients? Do they always have family members who are paying their bill? I mean, even with modest fees, you're talking about $3,000 to $5,000, I'm guessing. And you don't have to tell proprietary information, but I'm just saying they have to have a family network. Someone who's a young male, 24, who basically has a strong case but doesn't have family, may fall through the cracks. That's the kind of two questions I have.
Yeah, so before Sci-Fi got rid of their immigration, it was a nonprofit that just got rid of their immigration program. I would receive a lot of referrals from them, from a nonprofit organization. I used to, when we first opened, I did mostly detained work because it was during the first Trump administration. And I took a lot of pro bono cases. I was trying to get I was trying to establish myself. And then I feel like in the middle of our growth, it was like an adjustment period where I wasn't taking as much pro bono. But I feel like now, 5 years in, we have more resources and people know, I get emails or I get phone calls about pro bono cases. They're like, oh, why don't you ask Alexis? So I really think it just depends on our availability, but we take pro bono cases like as we are available. I haven't teamed up with a nonprofit specifically, but when people come to us and I see that they're a case that I can't take or that they can't afford our fees, if I'm not able to give them a low bono or pro bono representation agreement, then I send them to specific nonprofits that I know might be able to help them. But the need is so great that a lot of times, like I end up pointing them towards resources where they can learn how to represent themselves. It's very tough. Like there aren't enough attorneys doing this, there aren't enough resources. But as much as I can, I try to do pro bono, low bono representation.
Thank you. And what do you tell a client who's going pro se?
So I tell them that, this is their chance. Like the judges see thousands of cases, so they have to present their case in a unique light and personalize it and be very detailed and make sure that they're consistent. And I tell them to look for these resources. There's certain websites that I lead them to, like ILRIC, GAIN, ASAP, and I mean, I feel terrible that I can't do more because I have so many clients, but that's basically what I tell them. And if there are cases that are going to take longer to get through the court system, then I tell them if you can during this time, like save money because it's going to help you so much more if you're able to get legal representation.
Thank you, Alexis. That was brilliant. Thank you so much for joining us. And now we've had a perspective from two types of sponsoring organizations for independent experts. Now we have the privilege of having Denise Slavin, and I'm going to ask Tom to say a few words about Denise, maybe a minute, because Tom is responsible for Judge Slavin to be here today.
Okay, well, thank you, Chip. Hey, Denise. And literally, I only have a few words. Judge Slavin and I worked together on some cases, and then she basically gifted me with her agreement to participate in a study that I was doing. And then she later asked me to do periodic presentations to law school classes that she was teaching. And I've just found her to be one of those judges who has a really, not only a rich history, but a very broad-based understanding from every angle. So when Chip said that he was looking for someone to speak from this perspective, Denise was, one of the first two people I thought of. So anyway, Denise, that's not a very comprehensive introduction, so.
Well, you can add a few words, Judge Slavin. Go ahead.
No, that's fine. I mean, I don't have much to add or anything like that. It's just, it's been a pleasure working with Tom. He is one of the best experts I've ever worked with. And I always loved having him in my court. So this is, first of all, I'm a retired immigration judge. Just retired after coming back part-time a little while ago. And now I do a lot of consulting and teaching. So let me just say, first of all, what are experts in immigration court? One of the most helpful cases is matter of DR, and it says that expert testimony, it sets the standard for experts in the immigration court. And that standard is based on the federal rules of evidence. Now, the immigration courts, like the Wild West, as most of you probably know, the federal rules of evidence don't exactly apply to us, and we don't have really concrete rules of evidence, but the Board of Immigration Appeals has always said they're helpful guidance. And the expert witness is broadly defined as someone who is qualified as an expert by knowledge, skill, experience, training, or education, and has specialized knowledge that will assist the immigration judge. So, and this is something that a lot of judges get confused on. You don't have to have a PhD. You don't have to have a master's. You don't even have to be a college grad to be an expert witness. We're looking for specialized skills, specialized experience, training, education, somebody who spent a lot of time in a particular country. It makes a good country expert. So that being said, I'll give you this quote. "There is no such thing as an expert in immigration judge proceedings." And this was a quote out of a case in 2020, over 10 years. And there were even earlier cases talking about experts in immigration proceedings. And this was something that a judge said in an immigration proceeding before him. Well, there's really no such thing as experts. So even though it's widely recognized in the case law, there's a lot of resistance to individual judges to taking expert testimony. I think some of it is the classic resistance that all judges have, like, I'm the one who decides this case, so taking someone else's opinion seems to usurp that. Then there's other judges, as I said, like me. I love experts. My problem is not going to town with experts myself and asking them other questions that I've always wondered about a particular country or situation. This is a quote, I think it's from Dickens. "A good lawyer knows the law, a great lawyer knows the judge." I think it's true for an expert too. A good expert knows the country, the area of expertise, but a good expert knows the judge too. And how can you get to know your judge? TRAC is from the University of Syracuse. You can go online. They did a Freedom of Information Act, FOIA, they have a continuing one of all of the immigration court grant and denials for asylum. And they publish those. So by judge, you can see, is your judge 5% grantor like the Atlanta court, might even be lower than that, or a 40% grantor like the Boston court. You have to be careful with that because you do have to consider the context. All judges who work in detained settings are going to be lower grantors on asylum because they're hearing a lot of cases that someone would be statutorily barred. And there's also the context of the type of cases and the countries that you're hearing. So don't be fooled by that. Don't be fooled the wrong way. I had generous grants when I was not entertained. I had generous grant statistics, and people would come in and think, well, I don't have to do anything. This judge is a grantor. I don't need an expert. I have an expert report that I pulled from another case that's similar to this. So I'm not even going to get my own expert report or call an expert. That's not necessarily true. The judge still needs the tools and the facts in each case to grant a case. There's 3 types of widely known types of benches. I'm just going to go to the next one here for a minute. There's the hot bench, the cold bench, and the focus bench. This angry guy here is the hot bench. He's constantly interrupting. He's constantly arguing with people. He constantly wants to know what's going on. This guy here is the cold bench, and we've had a couple sleepers, actual sleepers in immigration court. But in addition to that, we have a couple people who just like they view their role as totally hands off. Let the parties try their own case. They're not going to do anything. Then there's the focus bench, and the focus bench is a judge who might come in and have like a couple of issues or a couple of questions that they really want to hone in on, and that's their area. So all of these judges can be difficult or have pros and cons. I mean, the hot bench, it's hard to control the judge. Can you object to a judge's question? The focus bench, though, is something really an expert can help with, because you can hone in on, if the judge starts jumping in at certain points and asking questions, you can hone in on what that judge's issue is and know how to come back a little bit more with some more information that might help that judge. The federal rule of evidence, we talked about this before. It talks about the qualifications for a judge. There's for an expert, that they're qualified by knowledge, skill, experience, training, or education. One thing, though, that is important to hone in on is that the testimony must be based on sufficient facts or data, and it must be the product of reliable principles and methods, and you have to show that the expert has reliably applied the principles and methods to the facts of the case. So in your expert report, and all of you have written expert reports, you know what's going on. I just wanted to get some things that I found were helpful to me in an expert report and are helpful sometimes to all judges. A written expert report has to be filed 15 days before, and it must include your CV or your resume. Filing it ahead of time is not a bad thing to do. The earlier, the better. Please use headings and subheadings. It just helps so much, because if I look at a case and my main issue is relocation, can the person relocate? Or is my main issue nexus, as someone mentioned, is the particular social group or religion the reason for this person facing the persecution, or one central reason? Then I'm going to look for that part in the heading, the actual opinion. State your opinion and state the facts backing it, and show how the analysis supports in an analysis of how the facts support each opinion. It's very important to do that, and I'm going to discuss in a few minutes a case that talked about that. State the degree of certainty. I loved as a judge being able to quote from the expert report. This expert is absolutely certain that this individual is going to face persecution, or this expert is 90% certain, whatever you can give me, or says it's more likely than not, or whatever you can give me that will talk about your degree of certainty. Be very careful that the facts of the case are consistent with the evidence presented to the court. And if not, explain why not. This comes into a credibility issue. When I was talking ahead of time with some of the presenters, I was mentioning one of the big ways I've seen expert testimony and a case goes south with a good expert, unfortunately, is if the facts that they base their opinion on are not the same facts that were in other written statements provided by the respondent or by the testimony that the respondent give. Now, this comes into play, especially with experts who are talking about, because you can have experts, I would say almost on credibility, wouldn't call it that, but somebody who is suffering from post-traumatic stress syndrome might have a very difficult time testifying in terms of their memory and their ability to communicate accurately all the facts. And so you might need an expert to explain what post-traumatic stress disorder is and how it affects that, and why the facts that come out in their declaration may be slightly different. Maybe, Your Honor, I was able to spend 3 sessions of 2 hours apiece. You've only had 30 minutes with this person, and it's really hard to get this information out of them. So please address that, because otherwise we have credibility findings. And if the facts on which your opinion is based are different than the facts found by the judge, then your opinion becomes useless in the case. And give reasoned consideration, I'm quoting that from some case, to evidence that could be contrary to your decision, especially State Department reports, especially things that the Department of Homeland Security is going to point to. If Department of Homeland Security says, this gang only has a presence in a certain area of the community, and the issue is whether someone can reasonably locate to another area and not face persecution, discuss what the State Department says and why that person can't relocate to the other area, or if in fact the State Department is misled or it's taken out of context in some way. Matter of JGT. I wanted to talk about this. I wanted to talk about the reliable factual or evidentiary basis for an opinion. In that case, the court reversed a judge's reliance, the board, on an expert opinion because the immigration judge did not identify evidence as the basis for the testimony that Hezbollah and the Mexican drug cartels may work together to target the respondent. And they gave the examples that the expert witness says that Iran targets political opponents in Mexico, but they didn't have, to the contrary, didn't have evidence that Iran carries out such activities in Mexico. And they said no facts or data were given in that case to support the statement that Mexico was unable or unwilling to protect the respondent from Iranian actors. The only facts that the expert had given was weaknesses in the Mexico's criminal justice system generally, and that a well-known journalist had been killed in Mexico, but that journalist had nothing to do with Iran or whatever. So this shows how important it is, this case, to show the factual and evidentiary basis for each of your opinions. Is your opinion in the scope of your expertise? Now, one thing in a classical presentation, you'll be offered to the court as an expert, say, in country conditions in El Salvador, or country conditions affecting people who are evangelists in El Salvador. And then you have to be sure that all of your opinions are following in that category. In this particular case, matter of MAMZ, there was a private investigator who had previously worked as a law enforcement officer and testified as an expert on general country conditions and cartel activity in Mexico. And the expert had concluded that an assault against the daughter of the respondent was due to her relationship to the respondent, because the descriptions of the man by the daughter and the descriptions that the respondent had given of the person who was persecuting him and threatening him matched. But the BIA found, the Board of Immigration Appeals found, that the testimony regarding the match was not part of the purported expertise of the witness. I read this and I thought, what a crying shame. This is a private investigator who had been a law enforcement officer. He probably did have some expertise about evaluating descriptions of witnesses, of perpetrators, basically. And if they had just put that in the scope of his expertise and asked him some questions to show that he had, how many times have you done lineups with witnesses? How many times have you been able to, have you gotten descriptions and you've been able to solve a case or move a case forward based on those descriptions? If that had been done, maybe this case would have turned out differently. So I'm going to get a little bit away from the substance. Telephonic testimony. I generally had no concern with having telephonic testimony in the court. And I hope you will see, I understand there have been problems with this. I hope you will see judges moving more towards allowing it. The reason is that to have someone in court, you're usually pretty concerned about demeanor issues. You want to look at the person, see if there's any clues that maybe they're lying. I've never had a lying expert, I have to say. And I mean, most experts, that's their reputation. They're not going to lie to win one particular case or something like that. So it's the actual having to see an expert in a case is not usual. Is not a usual requirement. But I understand some judges have been to the contrary. And I hope that, you know, if you do it far enough ahead of time, you might have a good chance on your motion. Get the DHS to agree to it. And the other thing is it helps, you might want to even mention in your motion that it will be quicker for the judge too, in the case, if we have a telephonic testimony, and help move the case along.
I
Because
should note, Denise, that the judges have increasingly been much more restrictive in my experience. And even with prior agreements, they just said, well, either the witness was not credible, therefore we're not going to call the expert, or they just say, we have the declaration. Whatever the reason, the judge is the final say in an Article 2 court like immigration court, I think.
Well, you have to, I mean, if you have the declaration, and that's where you have to have some argument, and you're talking about not calling the expert at all. And that's where you have to have some argument. And that's, judges like to do that these days, and will very much like to do it under the Trump administration, because there's an emphasis on the need for speed, getting the case done quickly. So you have to be able to proffer to them something that the expert is going to do other than just relying on the declaration. And if there's, for example, if you could, in that same situation, well, Your Honor, the Department of Homeland Security has brought up a new issue with respect to country relocation or whatever, then, and the expert needs to address that. Then that's some, you know, if you can point to something that you'll be prejudiced by not having the expert testimony there. So that's something you have to talk to your the attorney you're working with about, is what can you say your testimony is going to add to the declaration? And if it's a stipulation with a DSS, if there's things, a lot of times DHS has come to me and said, well, we want to ask the expert particular questions, just hone in on this particular area. So if you can work ahead of time with the DHS person, you might have the DHS person on your side about the need to call an expert. But you're right, it's problematic in this area of need for speed. And you want to do a good declaration and be comprehensive. It can be hard sometimes to justify calling the expert. Other considerations, generally, the respondent testifies first, but there may be times, and you should talk to the attorney about it, that you might consider having you first. And this might be helpful to the expert if you're very busy and you don't want to wait, like a case is supposed to start at 1, you don't know if you'll be called at 2, 2:30, 3, 4. It might be easier for you to be called first, and you can that can basically set the stage for the respondent's testimony. And I've had many cases where the expert's testimony was the most crucial testimony. And once we called the expert, the respondent did nothing other than swear to the application, and we were able to go forward on that. Remember, I have the picture of the gymnast here because in terms of testimony, remember the principles of primacy and recency for learning and talking to people. People tend to remember the first things and the last things that they hear. So make sure you finish strong, save that nice, strong series of questions for the end of your testimony. So who is everyone's favorite expert? If you haven't seen My Cousin Vinny, you should see it. It's a fantastic movie. And she was just, she's dragged on the stand and sort of against her will begins to testify about her expertise in tire tread. And she just becomes an amazing expert witness. And why? Because she knew her stuff. She backed up every opinion with overwhelming facts. She could sit there and cite like every year that a car was made and which tire it had and different models, et cetera, and she exuded certainty. So that's what judges are looking for in experts, generally speaking, that you know your stuff, you're backing up your opinion with facts, and you show that level of certainty. And finally, I just wanted to say thank you for inviting me. We're going into a hard time, and I'm going to be sticking around a little bit to talk about some hard cases, but I want you to know I appreciate your work. Many judges do. Expert testimony is very important to the immigration court, and I think it will be even more important in the upcoming administration.
Thank you so much, Judge Slavin. And you and I and Tom will be speaking after Tom's next presentation. And Tom will give the view from the expert on how to work with lawyers. And Tom, if you would also not address someone who's very experienced like you, but also the novice expert not a novice in their expertise, but a novice to the immigration system, how they should deal with lawyers, because when you have tremendous expertise over a long time, you've been through courts and you may not even know the law better than, let's say, a pro bono junior associate in a big law firm who's supervising the case, for example. Take it, Tom.
Sure, thank you, Chip. Okay, so there's a few things that I really want to highlight. And again, this is primarily for people that are either entertaining the notion of serving as expert witnesses or that are fairly new, but are interested in continuing. First thing, it's really important to understand that attorneys are not a homogeneous group of people. There's tremendous diversity in terms of their understanding and knowledge about the conditions that characterize and define their clients' countries of origin. Speaking of the historical, political, social, cultural, economic, gender contexts of the countries. There's also great variation in their knowledge of the particular factors that forced their clients to flee under precarious positions, whether that's gang-related organized crime stuff, gender-based violence, LGBTQ issues, whether it's state-sponsored violence. There's great diversity in terms of the attorney's understanding of those variables. And also, as Chip was just alluding to, when you get into things like some of the big firms that have accepted cases on a pro bono basis, there's tremendous diversity in the attorney's experience, not only with asylum law per se, but in the immigration courts versus the courts that they would normally practice in their particular field of law, whether that's criminal or civil. So a couple of things that come into play here. If you're dealing with, and there's a broad spectrum of attorneys who represent asylum seekers. They may be full-time immigration attorneys. Part of their practice is other elements of immigration where part of it is asylum. There are non-immigration attorneys who periodically do asylum cases. There are, excuse me, the large firms that pick up many pro bono cases and then typically assign teams of attorneys, of associates to the particular case. And you find also advocacy organizations like the ones that a couple of our speakers touched on today, Michelle and Monica. You also find occasionally you get like law school clinics or legal clinics who represent people, but in a very diverse array of case categories. So the understanding on the part of the attorneys can vary tremendously.
And I would add, law clinics are using second and third year law students who are taking an immigration law course, for example, but they have no real experience at all.
Right. They're what would be considered pre-baby attorneys, in that this is actual part of coursework for them. So if you're a person who has a background as an expert witness, it's more than likely, as Chip just alluded to, that you're going to know infinitely more about the country conditions at play, the thematic issues at play, and even the context of the courts than are the attorneys who you are now working with and for. On the other hand, if you're new to expert witnessing, this all may be entirely foreign to you. You're going to come in with your country and thematic expertise, but the context of the court, the political nature of the court, the policies, the practices, the vernacular of the court, these are for a period of time going to be very new to you. So you may be asking the attorneys for guidance around all of these different issues. I think it's really important to point out for people that are entering into expert witnessing on a new basis is that your country and thematic expertise is really well established, or you wouldn't have been contacted to serve as an expert in the first place. But what's going to be new is that you'll be entering into a very new professional arena where you don't need to make yourself a lawyer. You don't need to make yourself expert per se in the court, although that's extraordinarily handy, and it would come with time. But you do need to have a working knowledge of how the courts function, you know, because just coming in with your country and thematic expertise doesn't necessarily prepare you to function as an expert witness. But again, part of what's important is that you may be coming in with expertise that far outstrips that of the attorneys you're working with. And so you need to feel that out very early in the process. If the attorneys are people I don't already know, when we do our initial case review, which typically is after they've sent me at least a sketch of the declaration and an overview of the case facts, I will then set up with the attorney an initial review just to go over the case. And part of that involves me, if I don't already know them, getting an understanding of what their experience is. So it gives me a starting line for what some of the contours of my role might be going forward if I end up assisting in the case.
Tom, I should note that, you know, the three speakers that we had today, typically from specialized NGO clinics or from a private immigration law firm, it's not going to be a situation where we know the law better than they do.
Right.
Just to be very clear about that.
Sure. And it's going to depend entirely on who the attorneys are you're working with. I've worked with dozens and dozens and dozens of attorneys over the last 18 years for whom this was their very first asylum case. And they knew absolutely nothing about the country in question. And they were very free in admitting that was part of helping to identify the starting line for me, because in that kind of situation where your attorney is either very limited or in some cases almost no experience relevant to the particular case, you're going to be doing an awful lot of consulting and schooling up of the attorney in a way that's going to be supportive of their efforts on behalf of their client. But if you're dealing with an attorney who's done lots and lots of these cases, obviously that's not going to be an issue. In terms of the dynamics of how we interact as experts with the attorneys, all I'm doing here is sharing my own personal experiences and preferences. This is what's within my comfort zone, and other experts, of course, have different feelings, and there is an entirely valid and equally valuable as my own. But number one important remembering is we're there as an objective expert. We're not part of the legal team. We're not there as an advocate. We are not there to help the attorneys develop legal strategy, to write their briefs to the court. We're not there to guide decisions about how they present their case. We're not there to help them prepare other witnesses that will be called, whether it's the asylum seeker or other fact witnesses, whether those are family members or other experts. That is really outside the scope of our involvement. As a matter of course, especially with attorneys that are fairly new to these kinds of cases, they don't oftentimes understand what the boundaries are for an expert witness. And again, I'm only speaking of my own boundaries. These are going to be potentially different for others, and there's no problem with that. But they'll say, what documents do you want to review? I say, I want documents that are going to inform my understanding of the facts of the case. Declarations from your clients, declarations from family members or other people with knowledge of the case. If there are autopsy reports, police reports, media accounts that you've been able to gather, those kinds of things are relevant. What I don't want to review are your briefs, because at some point a government attorney or judge may say, what documents did you review in preparing your opinions here? And it's really important to maintain very clean lines so that you can continually assert correctly that you're here as a neutral and objective expert and you're not part of the legal team. If you review your attorney's briefs, it could easily be alleged that you have now tailored your declaration and your testimony to align with the brief and the legal strategy of the attorneys. And all manner of unwanted and unwelcome things could roll forward from that.
Thank you, Tom. We're going to move to our three-way discussion now because
Sure.
Judge Slavin has to leave presently. So this next section, we have about 15 minutes maximum. We're going to have a three-way conversation before Mark Unger comes online after our presentation and discussion. So Tom just presented one example of a hard case. And related to that would be, when does an expert say no? Obviously, in terms of what you think of the situation, if it doesn't convince you that this person has a fear of persecution in some kind of general way, you don't want to get too legalistic and usurp, as Tom pointed out, the role of the lawyer, but you do not want to be in a position where you compromise your integrity, your reputation, and quite frankly, your honesty. But those lines can be difficult to draw. And so a hard case might be a situation where you think it's persecution and it sure sounds right, but they don't have the documentation, right? So you would be in a situation where you would honestly testify, I think it's the case, but because the person ran for their life and couldn't get the police report, I don't know for sure about the individual's credibility. So you would say, maybe, if the court believes that this story told by this particular respondent is true and credible, then it fits into the overall pattern of what I know about that country. A second example, and I'll go through this list pretty quickly, we alluded to earlier, someone is in a social group, like someone who is trans or someone who has been subjected from cultural practices like FGM against the will of a minor, for example. These cases are hard to prove, and you need to think carefully about whether you have that specific expertise. And you really don't want to be an expert just because you know the country on FGM or forced marriage, let's say, because that is beyond your expertise in the country. You might say, I can testify to the fact that this country is generally conservative, but I don't know this particular tribe in this part of the country. If you have the chance to interview the applicant or the respondent, generally it's advisable, but lawyers may advise against it. But you should, if you do, talk to the person, because you'll come up with facts that the lawyer may not come up with, facts that ought to be included in the narrative and declaration of the applicant. But if you decide the individual's not credible yourself, then probably or almost certainly you should not take that case. I already alluded to the situation of limited documentation, where it's going to fall much more heavily on the credibility of the client. That's not your responsibility, but it will be a situation where you're going to have to admit that you don't know whether the person really had the story that they did, but everything the person told you is consistent with what you know about the country. If you're dealing in a situation where you have been called to the court and the attorneys haven't had time to prepare a good case, that would be theoretically a dilemma for an expert witness. You want to help the person, but this is an overworked public defender who's taking the case pro bono and may not have done an immigration case before. Increasingly, that is going to be the situation, perhaps speculating into the future, where there are so many people put into expedited removal that anyone who's an expert witness might be called upon to come and get involved, but that attorneys are just doing it because they feel these people in these mass detention centers that are created overnight and are scheduled for removal need some kind of help no matter what. And the lawyer volunteers to get involved, and the lawyer really doesn't know the ropes yet. Then there's a situation of past voluntary removal where quite often you might want to tell an attorney that they might want to think about talking with the client about taking voluntary removal, because after months or years in detention, they want to get out of there. But that means they can't apply for asylum or can't legally apply in the country for a long period of time going forward. There's a situation of aggravated felonies where, you know, you're probably testifying on behalf of a drug dealer. It's not your role to, I would recommend, to ask the client, well, what felony did you perpetrate? But some experts might not want to be people who are convicted drug dealers or convicted murderers even. A lot of people that you would take in immigration court over the years will be people who've served time, and it's up to you to decide whether you want to ask the person, what do you serve time for, before we go for the scheduled removal hearing and process going forward. Then there's the situation of multiple prior country entries. You know, if someone came to the United States through 2, 3, 5 countries, at least in law, although the typical pattern is to remove the person to the country of origin, you might have to prove the country conditions of all the countries that the person went through to show that there's not one of those countries that they couldn't be deported to, even though they have no family, no friends, maybe not even speak the language, but they walk through 5 countries to get there. Most judges don't do that. It would be a hardship. The lawyer should actually say, removing the person to country Y, which they happen to walk through in the jungle, would be a hardship and would be unreasonable. But legally, I think a judge has that discretion. Finally, you know, Convention Against Torture versus Asylum claims raises a lot of questions, because you're going to be asked, what is the probability of torture? It's generally said that a CAT claim, as opposed to an asylum claim, is more difficult to prove. But my experience, and I think a lot of people would say, is actually, if someone's been tortured before for their political opinion, that's easier to prove because the government is either unwilling or unable to prove it. But there's a lot of gray area in those cases. So that's the sort of thing that would be among these laundry list of dilemmas that I presented. So I'd like to ask Judge Slavin, before she leaves, to comment on anything I've just said, or another hard case that you may have thought of.
Well, the first thing I want to say is that it's really good for your credibility if, as an expert, if you say no to cases. And one thing that, you know, you might not mention it in your report or whatever, but one thing the Department of Homeland Security always cross-examines people on is it true you've always testified for the respondent, which generally is, because DHS doesn't seek experts. But
and that's what I always say, is that no one's ever asked me. But
another comeback for your attorney after that is say, ask me if I've testified for all the people who have hired me, and, or, you know, have tried to hire me. And then you can say, no, I don't. There have been times I've turned down cases. And that again bolsters your credibility, that there are times that, you know, your expertise didn't match what was called for in that particular case. So I think it helps, you know, if that happens, if you've done that you should let the attorney on the other side know, because if an attorney that you're working with know, because if the bias question does come up, I think it's not a very good question. It doesn't come up in all cases, but if it does come up, then you have a comeback to that, in addition to DHS doesn't hire people to testify on that. I think one thing that an expert that is a hard case is what I would call the unbelievable cases. And that is when you have like torture that's kind of bizarre and extreme. And I know one person commented about a particular immigration judge that if Anne Frank testified to him that she was locked up in an attic all this time, that he would say, well, that's totally incredible. That could never happen. But there are those cases like that are just extreme. And to the extent that you can say that is consistent with other situations and point to, you know, and talk about other situations that it's happened in, it really does help the credibility of the respondent in that case. And finally, I do agree with you. I think with respect to CAT, there are the big problem in asylum cases is fitting into one of those categories and showing a nexus, that your fear of persecution is based on race, religion, nationality, membership in a particular social group or political opinion. There are times when people have been subjected to persecution that doesn't fit into those categories, but it rises to the level of torture. And for that reason, the department, and even if it doesn't, sometimes the department's willing to look the other way and say, yeah, we don't agree to a grant of asylum, but we would agree to a grant of relief under the Torture Convention. And I have to say, my understanding is that they're monitoring of their discretion. They have more discretion to agree to CAT grants than asylum, because it actually gives less to the respondent. It doesn't give them work authorization or path to citizenship or anything like that. So it's something to think of. Torture is, one of the things about torture is fear of imminent death. If a respondent is put in a situation at one time in the past where they, I always, when I'm talking to attorneys or young attorneys teaching them advocacy, if a respondent's put in a situation where he said he saw his life flash before his eyes and thought he was going to die and he would never see his wife and children again, that was torture by definition under the act. So it's something to remember and sort of look at to see if they found those types of situations. So that's the only things that I would add to what you have to say about the difficult cases.
Thank you. And Tom, do you have a few words? Because we're a little bit behind schedule.
Yeah, there's just a couple of things I wanted to chime in on partially in support of what you two have said. The failed credibility or failed credible or reasonable fear interviews can be a significant issue. And part of what I will do if I'm involved in a case where that's happened is if I'll ask for a transcript of the interview and just see how the conversation went. And what I've found a lot of times is that the interviewer themselves really seem to have lacked the background to ask the appropriate questions that would allow him or her to arrive at a more balanced, comprehensive conclusion about the legitimacy of a credible or reasonable fear. And that can be helpful for the attorney who's now handling the case. The issue of non-credible respondents, and Denise, you touched on this a little bit when you were talking about trauma, but when you're talking about people who have fled violent situations that are from violence-affected countries, there's a lot of factors at play that can be misconstrued as credibility issues. There's the trauma that Denise mentioned, and just the pure neurophysiological effect on trauma, on cognition, recall, a whole range of elements of brain function. There's also what I refer to as a conditioning to silence within these countries, where people don't talk about this stuff, even within their own families and their own intimate groups. So that oftentimes what one member of a family knows, the others don't. What one respondent knows in a case, the other ones in the same case may not know. And this can all go to credibility. And it just is an example of how cognition and things can affect this. I worked at Chip, I know we need to move along, but I think this is a stellar example. I worked on a case of a young woman who, when she did her credible or reasonable fear interview at the border, said she was raped by 4 men. Well, during her hearing, her asylum hearing, she was subjected to some pretty intense cross-examination by the government attorney, and she said she was raped by 3 men. Well, as what happened eventually came out is that she was physically held down by 1 of the assailants, while the other 3 subjected her to rape. And in her mind, she conflated the person who held her down as one of the rapists. Well, this became a credibility issue that had a really adverse effect on her case. And as experts, we can assist with those kind of things. So, Chip, I'm just going to stop there because I know you've got some time pressures.
Thanks so much, Tom, and to Judge Slavin for joining us. Now we're going to turn our attention on different focus, more specific niche topics. Mark Ungar of Brooklyn College, CUNY in New York City will speak generally about police violence as a form of persecution and what his experience has been dealing with clients. Mark, and would you say a few words about yourself?
Sure. Thanks so much for inviting me to this presentation. I am a professor of political science and criminal justice at the City University of New York, the Graduate Center, John Jay College, and at Brooklyn College. And I've been working in Central America for 20 years. Guatemala and El Salvador less so. In those 2 countries, I'm coordinating a project on arms trafficking in those countries, which is a huge cause of violence. and I coordinated a project for USAID for 2 years on extortion. And I've also worked in Nicaragua with the opposition. But most of my work, where I am every couple months, is in Honduras. I was on a Justice Commission, a Police Reform Commission, UN missions, etc. Currently, I'm working with several NGOs, ACJ, which is a network of NGOs, and Sepuro, which is social service agencies, on various projects. And I want to focus on one of the main causes of asylum seekers from Honduras, which is police violence and collusion. Let me see if I have a very short PowerPoint. Let me see if I can share. So this is, I just want to touch on 4 things in the limited amount of time I have. I want to turn to organized crime in a minute because I think it's very helpful for the courts and for judges to have a paradigm shift in understanding how the state functions in Honduras and obviously many other countries in terms of the structure and power of organized crime in that country. But first, I want to turn to the focus, which is the set of state agencies responsible for security issues, which are often one of the reasons why people flee. First is the police. In Honduras, you have a very corrupt and collusive police that work hand in hand with the Maras, MS-13, and Barrio 18 in these areas. The
You
police
just mentioned
had,
both of the names of gangs.
yes. So people refer to them as gangs. In my affidavits, I always call them Maras and point out to the court that the what's connoted with the English word gangs is very different from what the Maras are in, at least especially in Honduras, in terms of their power, their transnational connections, etc. So yes, the Maras, often referred to as gangs. But going back to the police, the extreme proliferation of police forces in Honduras, where there's constant restructuring, there's constant creation of new units. Many of those units collaborate with organized crime. They're very autonomous. On gangs, there's been in the past 10 years, 15 different units working on gang violence. So because of the politicalization, because of the lack of control by the security ministry over the police, they tend to be very autonomous units in terms of staking out their criminal enterprises in the neighborhoods, making connections with transnational drug traffickers, etc. Collusion is very extreme in terms of all the major kinds of crimes, particularly extortion. So as I mentioned, I ran this project on extortion for USAID, and we found 70% of people paid some kind of extortion. No one reported it, and many of them said the police were involved. There's very few channels to report it, etc. So when people are fleeing gang violence, what I try to point out in my affidavits, they're fleeing gang police violence because they work hand in hand in most of these areas, and there's no differentiation as far as daily life goes between them. And in almost every case that I've had, most people don't report attacks by gangs or killings by gangs to the police. When they do, the police either refuse to do anything or they report it to the Maras themselves, who are implicated in the killing or the violence. Third is criminal justice, and I focus a lot of my attention in my affidavits on the whole criminal justice system in terms of tracking how it all operates. You obviously have the ability to file reports by the citizens, crime reports, most of which don't happen. And also the lack of investigators and prosecutions. We did a study when I was on a commission, Comayagua, which is a high crime rate city in Honduras, and of 400 murders over a year, only about 30 were actually investigated because there was a lack of prosecutors. Prosecutors often don't have the equipment, they don't have the support, they're often threatened, they don't get security, etc. And very few cases, therefore, get to trial. So only 3% of these cases by gang related or get to actual criminal trial. And so people don't report because they know this. They know that their cases will not be investigated, will not get to trial by the court. And then finally, the larger question, and Judge Slavin talked about, the conditions of returning. And when there's a change in government, this comes up a lot in affidavits, particularly when the client fled before the government change. This has come up, Guatemala is a good case where you have a better government, in my opinion, than you did before. Same in Honduras. At the same time, even though the government in Honduras is much better than the previous one in terms of human rights and corruption and police reform, they're very stuck in terms of their legislation is blocked in Congress because the opposition has more candidates. And also, and this is very common in El Salvador in particular, the pressure to crack down on crime has led governments to be very dependent on police. And so the emergency declaration in Honduras, which, like in many other countries, the government is trying to replicate the Bukele model in El Salvador, which is very popular. But the result being that the police just end up carrying out a lot of abuses, a lot of circumstantial evidence detentions, so that 99% of detentions in Honduras under the state of emergency have been thrown out because they're not the investigation. So policy and government, even if on paper it looks good, often gets stuck. Let me just go to the second. I want to come back to the organized crime. And what I've been doing more in my affidavits, based on the work I've been doing there, is trying to convey the fact that most of Honduras, people live under very tight networks of organized criminality in their areas. So it's a small country, but in each area, you have these extraordinarily powerful networks of transnational cartels, family businesses, corporations, local officials who are, connected with them, landowners, etc. And they all collaborate on drug trafficking, human trafficking, environmental crime, narco ranching, and things like that. So I mentioned some here, Los Sobrinos Soto, which dominated some areas. This family, for example, was identified by the narco trafficking police as responsible for hundreds of killings, and yet a lot of them remain at large. Los Valles, Los Cachiros, which is a famous narco group that collaborated with the former government. The Zelaya family, who is connected with the current government, has huge connections with narco ranching at Olancho. So you see everywhere in the rural areas, and I have, working with a lot of clients coming from small towns or rural areas whose land is invaded or subject to attack, and also in the urban areas. So these two maps on the left here are San Pedro Sula and Tegucigalpa, where the red and the blue areas show control by MS-13 and Barrio 18. And these are not maps by NGOs. These are maps by the FNNAP, which is the anti-MARA police. So it's not a biased or based on an NGO, but the government itself acknowledging that they lack control over their own urban areas. And obviously, this would not be possible without the collusion of the police in these areas. So I'll stop there.
Could you say a little bit about the difficulty of making a case for police violence as not just ordinary criminality, and it fits into this category of persecution? And Tom might want to say a word about that too.
Can you repeat the question?
Just, in your experience in court itself, the ICE cross-examination of you would point to the fact that, this is just common law crime. This is not political, racial, religious, or even social group. And you alluded to the idea that the government is involved, mainly through the police, but maybe also the politicians. So would you speak to that connection and whether it's persuasive in your experience?
It has been persuasive. In most cases, the petition is granted. And I argue because this is a sense of de facto governance, is that people living in these areas and the clients who are petitioning for asylum are living under a political structure of organized criminality that involves the government, local government officials, local judicial officials, the police, local businesses, et cetera, and transnational cartels, particularly, which are very powerful. So based on the fact that, part of asylum claim is the state is unable or unwilling to protect them or defend their rights, is appropriate and relevant in these cases because that's the situation there. So they're not just unlucky victims of crime, but they are, the state is not protecting them. And they're often, if you report a crime, I've had several clients who were witness to a police abuse and then the police attack them I mean, literally, they were across the street and they saw the police kidnap someone or kill someone. They're attacked. So anyone, they're identified as a target. So they're not just a random victim of violence, but most cases, their involvement in crime leads them to be specifically targeted based on their identity as a family member of someone who's targeted, as a witness to something, et cetera. So those things tend to be convincing for the court in terms of the criteria for asylum or CAT.
Thanks so much, Mark. Tom,
Can
quickly,
can I jump in with just something as a follow-up to?
but very briefly, Tom.
Sure. What Mark was just referencing is this question of inability or ability and willingness, or more realistically, inability and unwillingness to protect individuals if they're deported. There's, just to follow up on that ever so briefly, myself and a couple of colleagues did a study and recently published an article on this, where the social construct that defines as a responsibility of the state the protection of individuals at risk from these criminal groups, which almost universally are colluding with state officials. This is not a social construct that's enshrined within the operating principles of law. So that what you find growing out of that is that the institutional structures, the resources, the experiences necessary to develop a whole continuum of protective mechanisms that would be necessary to address the security of people in situations like Mark is addressing, those simply don't exist. And a big reason they don't exist is because of the infusion of criminal elements with state elements. And this becomes a really critical piece to address in declarations and testimony.
Okay, thanks. We could talk forever on this topic, but we're a little bit behind schedule. So I'd like to invite Rob Smith to speak on helping clients prepare their own testimony, as well as anything that Rob cares to speak about relevant to our topics. And would you say a word of identification as well, Rob?
Sure. And Thomas and Mark, if you guys have articles like the one you just mentioned, if you drop them in the chat, I'd certainly be interested in reading them. This has been really fascinating to hear. So I'm Rob Smith. I teach at the Grad Center at CUNY and at Baruch, and I've been doing deportation, asylum, CAT, and withholding cases on, for 30 years, mostly with Mexicans. I've done a lot of field work in Mexico and in New York. That's where most of my work is. And a lot of the work that I have done focuses on getting and it's practice. I'm usually working with lawyers who have people going to court, or I'm working like perhaps in an organization telling people who have court dates but not lawyers that one of the key things for them to be able to do is engage in causal storytelling in a way that fits in to the framework of elements that the asylum officer or judge is going to look for. Because, and I was very grateful to hear some of this before, as people noted before, there is a tendency for people to either just tell their story, and most people they're not accustomed to telling causal stories every day, right? We do it because we're professors, right? If you're married to a lawyer, you hear it all the time. But most people just tell stories in terms of this happened and that has happened. So there's a sequence of events that don't add up to causality quite often. And it can, and often the focus is on either the most traumatic thing, and then very often, if there's a trauma that's been kept a secret in the family, if you have another family member there or something else, there's a massive and oppressive silence about this. So I think I always do extensive interviewer interviews with the people that I'm working with, because you really need to know their story in order to be able to help them establish a causal storytelling framework. And so when
I
you
ask a brief interjection, because I've occasionally had a judge say, "Oh, you're biased because you talked to the client." Have you ever come across that, or maybe the New York judges are just so much more?
I've never had that. It sounds like well, I mean, for the way I've done it, it would be an obstacle I would have to figure out how to get around. But I don't understand how you can do a proper analysis of somebody's claim without knowing the particulars of it. And one of the things I've also found is that when I interview someone, even if the lawyers have interviewed them a bunch of times, I always come out with insights about things that they don't know to ask about because they're not expert witness, they're not experts in the area. The stuff that Mark was just talking about the police being, not just the agents to protect people in theory, but also the agents extorting or oppressing them. I think that kind of local knowledge and calling them maras instead of gangs to avoid the West Side Story connotations that these are actually alternative governments. I do exactly the same kind of thing with cartels when I'm doing such interviews. And I know the
I
names
just say
of,
that I agree with you 100%, but we in Atlanta, where we have a 1 to 2% approval rate, they just give one reason to reject you or
is
your
that you're
argument.
biased because you've interviewed people?
Yeah, and so it's not a straight call. In the circuits, we have 13, all these circuits in the United States with different legal standards, and the Northeast and Northern California are going to be the most, call it, open to respond to claims. But I certainly agree
My
with you on the
thinking
merit.
about it then, Chip, is you should talk to the lawyers and tell the lawyers the questions you need answered, and then get the answers from whatever they
Absolutely.
extract.
I mean, there's nothing better than you interviewing the client. Don't get me wrong. We elicit facts and things that the lawyers are not aware of.
Yeah. But yeah, so I guess I've been operating in a luxurious environment without knowing it. If talking to the people whose story you're supposed to analyze is seen as bias, then I don't understand. I mean, the
Well,
judges can
I think
also
the
talk
legal
to
theory
them.
would be on the part of the judge is that you're not here to assess the credibility of the applicant or respondent, and therefore you're being influenced by their story. You're here to say, if given a story that they provided the court, and you often are not there because most judges don't have the witnesses to even be permitted to be in the courtroom when
That makes sense to me in a certain way. I think that makes sense. So
trigger
that
passing judgment, if the story is true, is it consistent with what you know about the country? I'll decide as judge whether or not I believe the person.
the thing I would look, and the argument I would make back, and my guess is that with a 1 to 2% approval rate down there, they probably will not buy this particular argument, is that the interviews enable you to get data, which is an objective term, get data on particular processes and forces that the lawyers would not know to ask about, and that the person might not know to be relevant to the story because they're not asylum officers or lawyers. So you can only, and I would also say, I'm only going to be able to testify on the data that I have. Like, I have lawyers for the government routinely ask me, like in deportation cases, have you ever told someone they're not eligible for, relief? And I've said, well, I never give a legal opinion because I'm not a lawyer, but I have told most of the people who ask me about this, I've told them I would not apply for relief based on the facts you presented because my guess is that you'll lose. So I think the way I would go into it is to talk about the disconfirmability of your conclusions. If you were to ask about all these things and there was no evidence of, Mara or cartel, like if they keep saying no to all the things are key factors down there, then it would make the case much weaker, and you would therefore have to report a weaker argument for relief. It's not a great answer, but it's the best answer I can think of right now.
Can
But
I just go ahead?
yeah.
Go ahead, Mark.
Yeah, just very briefly, I usually have a section on their specific town or place where they're from. Many cases I've been there. Sometimes I know the police station where they file report. That's always, judges say and lawyers say that's valuable. And I've never had anyone, and I give testimony all over the country and to the different circuits, and no one's ever said that talking with the client and especially for that section on their specific town, was problematic or somehow biased.
It's
Another thing, I do the same thing. Like, I know the municipios where many of these people are coming from, and I know of, kidnappings. Kidnappings are a big piece of it because of Mexico now is ranked #1 in terms of kidnappings and death in the world. So you're not only more likely to get kidnapped there, you're more likely to die from it. But the other piece of this is if I interview the people and I get back into specifics with the internet today, I can find pictures, for example, of somebody whose relative was cut up into plastic bags and left with a threat written, to the local saying, you'll be next, and naming her family particularly, right? So it moves it, and they don't know to look for this particular thing, but because I know there's so much stuff out there on blogs and other things, I can actually strengthen. And I also, so when you're doing these interviews, there's 2 or 3 key things. You have to set the context for the person to know to tell you causal stories. One is you've got to tell them about this concept. Another piece of it is you've got to tell them why you're asking these questions, right? And you have to tell them why and how, what the asylum officer is going to be looking for, right? The well-founded fear based on membership in a group that the state is either doing it or complicit or is refusing to protect you, et cetera, et cetera. And they're not super complicated questions in their most elementary fashion, and people can answer them quickly. I think it's just a thing of traumatized people don't think to tell their stories that way, and most people don't. So I think another piece of it is, I think I often reassure people I'm interviewing that they don't have to prove everything, that I will help them where I can to show things that, like, for example, when they, I don't know who the Mara was, but it was in this town and they left a note and blah, blah, blah. They give me 3 or 4 pieces of data and boom, I can usually find something. And I think that these are valuable ways that we can help elicit stories and help the person to organize them, right? And then I actually have the person sometimes tell me the story, right? Because if you practice your causal storytelling, that I think solidifies it, because it's very nerve-wracking in court, right? And if you're not used to it, and it's high stakes for these people. I think these are some of the keys of the things that I was gonna talk about.
Can I pose a question to the 3 of you, which is, have you testified on behalf of police who are trying to be honest? And how did you frame your declaration and your testimony?
I have worked on a case that did not move forward, but the person got withholding, and it was a police officer in El Salvador who had been threatened with death because of her police work, and I forget precisely the pieces of it. And she came to the U.S. and did not understand the asylum system and could not apply for asylum because she had passed the year-long deadline. She didn't try to apply for till 3 years later. But the case was so strong they immediately granted her the withholding. The government stipulated. So I didn't have to go into court, but it was a pretty interesting case.
Mark or Tom, do you have anything to add?
Yeah, I've done a lot of cases where police officers and few military officials were either threatened by criminal groups or they were threatened by their corrupt counterparts within the police or the military. I find them to be really compelling witnesses. They're very well trained in most cases, unlike a lot of the people we work with who are unable, like Rob is talking about, to really tell their story in a coherent manner. And so I've found them to be very easy cases to work on. And oftentimes, in fact, always, I can say, the attorneys end up framing them within a political opinion context vis-a-vis the officers' pro-rule of law, political social values, as demonstrated by their involvement in law enforcement activities, which is what got them into a situation of being targeted in the first place.
Yeah, I've had about 6 or 7 cases of police, and also similar as Tom's experience, they're really strong cases, and their identity as a former official, I mean, their social identity is very well regarded. The military is harder because the lack of access to information. There's internal military procedures that are very difficult to verify. But among the police, and it's incredible how, in the cases I've had, police who are threatened or police who blow the whistle on something, the lack of protection or support they get from their superiors is it's been consistently absent. And it's always shocking. I mean, it shouldn't be shocking, but it's incredible. And that just kind of affirms their case.
Rob, do you want to say anything more about prepping clients that you've interviewed?
I think sometimes you need to do more than one round with people, particularly if they've been especially traumatized. And I think, and this is the way that memory works and the way that trust in that developing relationship works. People are not going to tell you everything the first time, I think. And so having more than one recommendation, more than one interview with them is good. And where it's appropriate, having more than one person there. Like sometimes if it's the husband, if the wife is there and very supportive, she will remind him, oh, remember to tell him about this, or remember to tell him about that. Now it could work the other way if that's not an appropriate, you know, you don't always know, but I do think that the explaining to people why you're asking them the questions, explaining to them that the the asylum officer or judge is going to look for these 5 elements and that you need to be able to connect them in a causal story, and that you know, I mean, emphasize they need to be truthful, but also that, you know, asserting there's a causal link is one of the things they should be doing. They shouldn't just be saying this was bad and, you know, this was another thing. And yeah, that's my main. I think the other piece of it is sometimes I think you have to prep the lawyers or help the lawyers in how to work with an expert and how to get more out of the interviews that you and they are doing with people. That's been my experience.
I should note that in Georgia, where we have the most restrictive circuit in the United States, you cannot often get into detention centers if the client is detained. Only the lawyer could get in. So prepping the lawyer for the discussions is basically your surrogate to try to elicit pertinent facts. And the storytelling that you're emphasizing, Rob, is really essential. And most attorneys have had more experience that kind of preparation of the witness, of the applicant. But our access, at least locally, when I'm doing telephonic testimony and the person's not in detention, then I can do all this kind of interviewing. But if the person's in detention in San Francisco, I'm certainly not going to get a Zoom call and FaceTime or anything like that. So this is where Tom's presentation on working with the attorney is really critical, is to prep the attorney on facts that you know that the attorney doesn't know about the country, such as these individual neighborhoods that both Rob and Mark have just alluded to. Well, at this point, we were supposed to...
I thought of one other thing, Chip. I also think it's important to prep the witness and prep the lawyer on testifying in the Zoom age, because I do think the Andrew's questions in the chat before and the answers from Mark and others about most of this used to all be done in person and now it's done often in Zoom. My observations have been sometimes that, and this was in a deportation, not an asylum hearing, that the Zoom, the platform they were using, it was pre-pandemic, the platform they were using made the respondent look angry and two-dimensional. And when he moved, he sometimes went in and out of focus. It looked like I was interviewing somebody in the Matrix, like one of the lesser characters with Neo. And the other piece of this, which his lawyer did not know, is that he was sitting in the detention facility on a small desk with a computer, and on the other side of it was an ICE agent who had told him he was going to get deported and then was eating his lunch and picking his teeth while the guy was giving his testimony, right? So it's no wonder he looked angry. So when I spoke to him again, I told him, the way you presented on there looked angry and it made you look like someone should be afraid of you. I said, what was going on? So he told me all of this. And so I didn't, my coaching, if you want to call it that, was to explain to him the way he explained things to me with all of his concern for his family and all that, those things didn't come through, and that he needed to ignore the ICE agent who would be sitting on the other side of the desk for him in the detention facility, and really practice focusing on telling the pathos of the story and his worries about his family. Because those were the things, I think, he won the case. Those were the things that ended up coming through. But this Zoom age, I think, is a very dangerous thing in terms of the rights and 14th Amendment procedure protections, etc. You guys would know more which particular provisions of law would be relevant in that thing. But I don't like it very much. I like it for us because it's easy for us, but I don't like it in terms of the client telling the story of their own story.
Well, I'll talk later in my turn about actually the restrictions on using audiovisual platforms for testimony that has, at least in some circuits of the country, become the rule. Did anyone want to say anything more?
Chip, could I just wanted to follow up on Rob's discussion about speaking with the respondents. I find that it's oftentimes very important, and I don't do this all the time, but at times to speak to the family members that remain in the home country because of this compartmentalization of information, people's fear of they don't want to share information with their loved ones who are now in the United States. So very frequently, the people who are in proceedings in this country are completely unaware of critical elements of their case because their family members haven't shared with them. I did an interview a couple of years ago with a woman's family. The MS had killed 3 members of her family before targeting her. She flees to the US. I learned that that 2 other family members had been murdered, and her kin never told her about it. She had no idea. So this can be a really critical piece.
I would like to invite Lisa Knauer to take over. And we've been talking about Central America while you were away. So we've had an in-depth discussion on Honduras and El Salvador, a little bit on Nicaragua, but we haven't talked about Guatemala at all. So I invite you to give us a few words of self-identification before you start.
Thank you so much. Great to be with everyone this afternoon. So I have been doing research in Guatemala and with Guatemalan and other Central American immigrants in the United States, in Massachusetts, which is where my university is located. Since 2009, I have been doing fieldwork in Guatemala, primarily in El Quiché, Huehuetenango, and those are areas that I've obviously drawn upon in my expert work. I've also been part of a couple of sort of investigative delegations organized by the Guatemala Human Rights Commission, which has taken me to a lot of other parts of the country. And I have been working, doing expert declarations and expert testimony since about 2012. So for the last 12 to 13 years, and primarily for Guatemalan asylum seekers, I have done some El Salvador, some Honduras, and a very small number of cases on Mexico, and on a range of issues, many involving indigenous Guatemalans and primarily indigenous Maya, many women, gender-based violence, land offenders, political violence, religious violence, people who have been targeted by gangs, debt, anti-LGBTQ issues, child labor, so a pretty broad range of issues. Do you want me to say anything more about Guatemala or just go right into the ethical issues? I can't hear you. You're muted, Chip.
Thank you. I think it'd be great to talk about how Guatemala and preparation witness is very similar to other Central American countries and how it's different, how you prep clients from Guatemala about their individual story. It may not be that Guatemala, as far as this strategy goes, is so different, or it may be that there really is tremendous differences from these other cases.
Well, I don't prep clients, and in most of the cases, I don't actually talk to the client. Most of my work with attorneys as an expert witness is just based on the written materials that the attorneys provide to me
Let
about
me
the
interject
respondent.
that Rob and Mark both said that they emphasize the importance of doing that in their own work. And I countered with, that depends where you're dealing with and whether the judge looks favorably or unfavorably about that. So
Yeah.
it's great to have a different perspective.
Mm-hmm. Yeah, I will, if there is something that is not clear, if there is something, and I will generally ask the attorney if this is something, do you know if the judge has a preference? Because I've worked on only a small number of cases where I was told specifically that the judge wanted to make sure that the expert had not had any direct contact with the client. In most cases, that hasn't been specified or not, but I haven't felt a need. In one or two cases I did earlier kind of in my career here, mostly because I felt that the people whose cases I was working on, these were young women who had been severely traumatized, and I felt that it was important to just reassure them that there was a human being who was working on their case. I didn't ask them many detailed questions about their case. I didn't want to re-traumatize. These were young women who had been kidnapped and held as novias de pandilla, women who were turned into young girls, actually teenagers who were turned into sex slaves of Amara. And so I didn't want to ask them to talk about that experience again because they'd already talked about it once. In some cases where I felt that there were issues that were very unclear in terms of the narrative, I again tried to work through and with the attorneys. So I think another issue, and I'll just say a few more things about Guatemala, and then I will kind of talk about some of the ethical issues that I think are involved in doing expert witnessing. So because there was a change of government in Guatemala, and because there have been some very highly publicized genocide trials, some of which have resulted in sentences for the perpetrators of the crime, and particularly sexual violence against women during the armed conflict. So one of the questions that I've gotten, on cross or from judges is, well, doesn't this prove that the justice system works in Guatemala? And my answer to that question has been, well, first of all, that's only a small number of cases. It took 36 years or 38 years or, a very long period of time, right? If a case that, a massacre or a women being held in a rape house or women and girls being systematically raped, gang raped in a particular community, in 1982, and we're talking 2024, that's, a very long arc of justice. And most of the cases still have not been adjudicated. There are over 250,000 victims of the conflict, and still mass graves, and still graves that haven't been excavated. So I think that's one. And then also the fact that, for example, in the case of the most highly publicized of the genocide cases, those of Rios Montt, the former dictator of Guatemala, never, the first verdict was trial was sort of vacated, and it was set back to, not quite back to zero, but it was kind of, the time was rolled back. And the second case never was completed before Rios Montt died. So that, I think, is one issue. And then another issue that's come up since the election of 2023 and the installation of Bernardo Arévalo, a somewhat progressive, reform-minded president who was installed in January of this year. Another, question is, well, but now there's, a democratically elected, progressive, reform-minded government. Doesn't that going to solve the problem of impunity and corruption? And in that case, it's possible to really take a deep dive or even a shallow dive into the State Department reports and into the current press in Guatemala, which I think demonstrates that the government doesn't change at all levels overnight, and that there's still many of the corrupt and undemocratic actors who were there in the previous administration are still there. The Attorney General is still there. The people are creating obstacles and really impeding Arevalo's attempts to reform and to root out corruption. And the president doesn't, directly control the police. So at many different levels, from having, judges, Congress people, people in the Attorney General's office who are themselves, many of whom have been put on the State Department list, on the Engel list, for corrupt and undemocratic actors. I think, kind of is a countervailing argument to this idea that having a reform-minded president means that corruption and impunity aren't a problem. I do want to address a couple of ethical issues here, since that's what I was kind of designated to talk about. And I think that, and I know that in some of the previous presentations, to the extent that I heard some parts of them, evaluating whether your credentials match those of the case, deciding whether to take a case or not. Do you think that the client's or that the respondent's claims are credible? And if you can make an argument in support of that, do you think that their case makes sense? In some cases, I've had specific knowledge of a particular community where there was a dispute and a respondent whose case I was asked to work on made a claim about the nature of the conflict in the town that kind of went against what I knew from having done research there and from having been there on numerous occasions. So I had to say to the attorney, I can't support that part of the claim. Here's the part that I can talk about. Here's the part that I can authoritatively say, I know from my experience as well as, reading published sources, makes sense about this conflict that occurred in the community. And so that is both, and I'm not getting into an argument with a respondent about what they saw or their point of view or their experience, but with the attorney to say, here is what I can argue. And this has also, come up again when attorneys have asked, can you state that, and sometimes it gets very nuanced, that, of the 23 Maya ethnic groups in Guatemala, that, there is discrimination against the Mam people. And I have, come back to that to say, well, I don't think there's actually specific research that I know of that says that one particular of the 23 or 22 Maya ethnic groups is discriminated against more than the other, but that I can say that there is discrimination against indigenous people in Guatemala, but I can't make that narrowly focused an argument. And to take one step back, and then I'll dive a little bit into a few details, which is there are many people like myself who do expert witnessing because we feel a professional obligation to put our professional credentials at the service of people in the communities that we work with and that we write about. So we, are kind of, and I will be very upfront, here with you, hopefully this is a safe space, that, are we upholding an unjust and flawed system by doing that? Would we be more effective working outside the immigration system and trying to change the immigration system? So that's kind of a big picture question that I think each of us has to answer. I've clearly and I know people who've done expert witness work for many years who no longer do it because they just feel so frustrated and so kind of knocking their heads against a wall. We're helping one person or one family at a time, but we're not really addressing the larger challenges of the immigration system and it's the way that it harms people.
If I may interject, that's a subset of the legal system generally. You can talk about war crimes law or business law, and if the defendant, if it's that kind of situation, has done what the government requires under the law, that can legitimate and legalize a host of evils. So as long as we target a military target in a residential building, and it's a real military target, that allows me to destroy a building with all the other non-combatant civilians inside. Or if I've done the product safety work on my legal aspect. It doesn't matter that the product poisoned 45 people. I followed the law. And so that would be the argument that perhaps an individual expert witness in an immigration context might want to think about it. I don't usually come to that side of the conclusion. I get a kick out of saving lives, and my life has been imperfect as anybody else's, but I know I've saved a few lives along the way. And that on a micro basis, it doesn't make this broader societal macro impact come to my mind most of the time.
Yeah, I think that we all make decisions about how we do our work or how we try to benefit and create a greater social good. So I'm just posing that. I'm not saying that one side is a better decision or a worse decision, but it's just, it is, I think, it does come to, I guess, maybe an ethical or maybe a strategic and tactical decision. How can I best use the knowledge that I have, the credentials that I have? Because I know the judge said, yeah, you don't have to be a PhD, but we know that that carries some weight in the world, that what I say carries more weight than, Juana Sanchez, who had a second-grade education in San Andres Acabaja, who talks about what happened to her. But my having those 3 little letters after my name gives what I have to say to substantiate and to say, yes, what she said is credible. Yes, it conforms with my knowledge. So I think that's, again, something that some of us play out in our minds. And I'm not saying that there's a right or a wrong decision. I made a decision. I did some work briefly with a wonderful organization, Al Otro Lado, that works with people on the border, on the other side of the border, and helping people, decide whether they think they want to cross the border and try to make a claim for asylum, and explaining to them what asylum is. And I thought, I think that I can be more helpful to people writing expert declarations rather than just telling people before they cross the border what asylum means. I have specific knowledge, specific skills. That's something that other people can do who don't have the training and the background and the deep country knowledge. So I made a strategic decision that was fine for, a couple of weeks of volunteering, but I was going to focus my energies on doing expert witnessing, and I haven't been back there. I think that
Lisa, can I ask you to
Yep.
take
Yes.
just 2 more minutes?
Absolutely. I think that there are a couple of issues in terms of how you write, what you write, and then whether you get paid or not. So how do you write, with a degree of kind of complexity and nuance that you know because of your deep knowledge and research, but that isn't going to obfuscate things and can make the point very clearly. So this is clearly very different from academic writing. And how can you make an argument that supports the claims that the attorneys and that the respondent want to make without reinforcing stereotypes, particularly in gender-based violence cases, without, sort of arguing that Mexican men are uniquely machista or Guatemalan indigenous men don't allow their women, that you're not reinforcing stereotypes about particular groups of people. I think that, how much do you flatten? How much nuance can you put in? I think that is a challenge in terms of writing. And then the issue of whether or not you get paid. And I think there are a couple of considerations. One is obviously your circumstances. Do you have a job? Do you have a job that pays you well? And, I'd like to go back to the example of, Woody Guthrie when he was asked if he would sing for free for a benefit. And the people said, well, it's a good cause. And he said, I don't sing for bad causes. So I think that, it's ethical to, if you can afford to not get paid, to do that. You'll get challenged by ICE, by DHS under either circumstance. If you do get paid, you're getting paid to make a particular argument. If you don't get paid, then you're just doing it because you're an advocate. So there isn't really one answer to that question. I do a sliding scale. It's not hard and fast, but I do some work pro bono. I do work for immigration law clinics at universities, or pro bono, real pro bono providers, nonprofits, single practitioners who are paying, or if the client is paying, I want to find out who's paying. And I charge differently for a fancy law firm where the first-year associates fresh out of law school, make twice the money that I make as a tenured faculty member at a public university. So those are
Thank
my
you
thoughts
very
about
much,
payment.
Lisa. Technically, according to our schedule, I only have 2 minutes to present, and I will be brief, but I'll ask Jenna Gilbert, our next speaker, to be ready to start 4 or 5 minutes later than we originally planned for our final presentation of the day. And I was going to speak, and this is a nice segue, on the whole issue of qualifying you as a witness in the court. And so this is a smooth transition. So maybe it was fortuitous that Lisa's schedule got changed. In any event, I want to say some general points, which is I've done this for 26 years since I've been in Atlanta. I did a few cases in New York before that. It's only in the last 5 years that I ever had my qualification seriously challenged in court. And now it's routine and systematic. So one instructional advice is the environment has changed, and it changed at the end of the Trump one and Biden. And the first thing they're going to challenge you on is obviously your resume and your CV. If it's a country conditions expertise, I don't do clinical or medical or PTSD and other forms of LGBT, trans, other kinds of expertise that an independent expert could be called upon to make. But in terms of a country, an earlier speaker today alluded to the fact that you have to have been in the country there recently, for example, if you're going to be credible about the current environment. And if not the current environment, because it's so well publicized, then the specific neighborhood or the specific person in this new context, where, as a previous speaker had mentioned, and I have mentioned earlier today, that a new government's in power, therefore everything is much, much better. So in the country that I've done the most of this work on is Haiti. And in Haiti, of course, you all have heard that organized crime gangs have taken over the country. Well, actually, yes and no. It's taken over all the cities completely in Port-au-Prince and Cap-Haïtien, less so in provincial cities, and they control the roads in between them. But in small individual villages, there's not much of a drug trade going on. So the gangs have not overtaken individual villages, although they have control over the national police force in a way that's quite startling. And as bad as things have been since the Jovenel Moïse assassination over 2 years ago, we have now seen in the last 3 weeks an unbelievable worsening of what was already an intolerable situation. And Médecins Sans Frontières, Doctors Without Borders, pulled out, which is probably one of the most important humanitarian NGOs in the whole world, and go into the most dangerous combat situations. They are not going into Haiti. I used to brag in a kind of sick way to say that I know the lay of the land, even though I'm a gringo, or similar terms that have been used for blanc, which is the white man or the foreigner. It technically means foreigner. I say I still can go in there. But even now, it's too dangerous for me. So I haven't been to Haiti recently. So if I get challenged on that, it's important for me to think about why I know what's going on there, how I follow the country's conditions. So I say things like, it's a small mountainous country. This is an urban resident. There's networks of communication throughout the whole country. Relatives exist everywhere in the country, even if the younger generation have moved to the cities. And even if some of them have moved into drug gangs or other forms of gangs like kidnapping for ransom, or some multidimensional organized crime machine that exists there. So I can say that I know for certain that this person can't escape anywhere in Haiti, and they can't get across the border because the DR now has a virtual or actual wall that they've been building for the last 2 years under this current president. And they can't get across the territorial sea, where the Coast Guard has interdicted Haitian boat people to the point where only 3 boats from Haiti have gotten into the United States, according to official US government statistics, in the last 10 years. So basically, the boats are no longer an option, so you have to go get on a boat somewhere and get to Venezuela and walk your way through the various natural and considerable geographic obstacles to get from Haiti to the continent and then up through Central America. To make a long story short, your qualifications are going to be challenged on country visits basis. Second, you may be asked to testify on a neighboring country where you know it really well. Like I know the Dominican Republic extremely well every time I go to Haiti, and often recently because of problems at the Haitian airport, I fly to Santo Domingo. But it's hard for me to be qualified as a Dominican expert, even though I can dance bachata and I know the music, merengue, and so forth. That doesn't mean a whole lot. So you have to be prepared to be disqualified in whole or in part. And you need to think carefully if you get disqualified as a Dominican Republic expert, let's say, or a Nicaraguan expert for El Salvador or vice versa, or any of these things, you'll be asked to maybe testify only on Central American country conditions, for example. And that, if the judge accepts that objection from ICE, you're probably not going to be very persuasive, and it's a very demoralizing situation. Third, in terms of qualification, you should point out that you've turned down cases if you have. Don't lie ever, but and don't ever lie about your most recent visits or lie about anything else. But it's very important not to come across, as Lisa just pointed out, as an advocate. And others have pointed out, Tom Borman pointed out earlier, you are an independent expert, even though you may or may not be paid. You've been invited by the respondent's lawyers, most typically. I know Rob has done some work on affirmative proceedings without the lawyers and or otherwise talking to clients. And that's really important advocacy work. But just because you're advocating for an individual who has a well-founded fear of persecution, or an individual who's more likely or not to be tortured. And therefore, you need to come across as saying, I'm doing this, I'm asked to do this because word of mouth is out there that I know my stuff, that I've got a good record or an excellent record, and not because I'm some sort of cheerleader for oppression by the US government. I turn down cases. I don't talk about the number of cases I've done, but if they ask me on cross, I'm not going to lie. And if they ask, if they challenge my ability to testify, as much more increasingly is being done, I want to just say this, I'm not an advocate on a cause. I'm an advocate for individuals whose lives are threatened. And most of the cases I've done historically, that's the case. Persecution, of course, can take on a variety of contexts, and I've, often asked, homosexuals in Haiti, or homosexuals in Iran, or homosexuals in Iraq or Afghanistan, and I can say I don't have to worry about the particular village and the nature of the police network, because I'm just talking about the attitude in the country towards that particular issue, and I've been to that country enough, and I've written about that country enough to speak authoritatively to it. So my main message before handing it over finally to Jenna Gilbert of Human Rights First is to say that you want to be able to speak confidently, 100% honestly about your qualifications, but remember the framing element. You don't want to allow ICE to characterize you as some kind of general cheerleader who will take any case, or someone who does this for a living. As I think possibly to retirement in the future, I'm not going to do this kind of work as an independent any more than I'm already asked, because then I might be characterized as a general advocate, and that's not what I do. And in that sense, that's the way the rules are written, and that's therefore I am conceding to the rules, and I believe in the rule of law. And if the rule of law is X, Y, or Z, I follow it. I'm not in there, to make a conscientious objection. I guess it's much better to remove yourself from a situation where you feel like you're supporting a system, if that's how you feel. I've never thought that way myself, but if you do think that way, then you should not get in a situation where your qualifications may be challenged. Okay, so finally, we have the privilege of having Jenna Gilbert join us from Human Rights First. It's a very interesting organization whose work over the decades has changed foci, and now it's a very, very active legal docket in 3 cities. Jenna, I've invited, and she's agreed to speak about the changing environment in the next administration for primarily independent experts, not for lawyers. So we've been trying to train independent experts, usually social scientists, but also medical and clinical personnel, or people who are experts in some kind of psychological situation. And so that's the primary charge I'm asking you to comment on. But of course, lawyers interact with us. So what you say to lawyers is also at least indirectly relevant. As you've tried to think about at least how Human Rights First and other law firms and other clinics are trying to face the prospect of mass deportation and everything that Trump has said publicly about expedited removals, the lack of due process that's likely to be, and the inability to house detainees in a safe environment. So it's trying to get them out of the country as soon as possible. And Jenna, if you would say a word of introduction, self-introduction, that would also be great.
Sure. Thank you so much for having me here today. As mentioned, my name is Jenna Gilbert. I'm the Senior Director of Refugee Representation at Human Rights First. So I oversee our organization's pro bono asylum work across the country. We have offices in New York, LA, and DC, and also run a robust Afghan legal representation project Afghan Legal Assistance across the country. You know, I'm very excited to be here today, actually. I know many of your names very, very well, though I've never seen your faces. You're on many of our lists of recommended experts for country conditions in many of our asylum cases. And so as Lisa was mentioning earlier, you're probably getting some first-year associates reaching out, asking for reports, as well as probably some requests from our staff for cases that we take in-house as well. So very grateful for the work that you do. And I have seen up close and personal over the course of my 11 years at Human Rights First, how impactful your reports can be. And they can really make the difference in an asylum case. So I just wanted to say a quick thank you to all of you on the call today. So I think I don't have much time. I know you're supposed to wrap up rather soon, but I think I just wanted to flag. What'd you say?
You can go over a bit.
Okay. Well, feel free to cut me off when you need to. You know, when thinking about how the role of an expert can and will change with the incoming Trump administration, you know, I think a lot about the ways in which we utilized experts during the last Trump administration, and just envisioning what we're seeing will likely come down the pipeline. I think that there are a number of ways that we can work together, attorneys and experts, to really help protect a lot of the clients that we're representing and ensure that they actually receive access to meaningful protection in this country through asylum, withholding of removal, or CAT. I think that one of the most obvious changes that we are expecting to see, and that you all should kind of keep on your radar, is we're likely to see potentially an entire elimination of the particular social group framework for asylum. But certainly we will see that gender-based violence claims and gang-based violence claims and family-based particular social group claims are going to be under attack, just like they were under the last Trump administration. And, you know, the interesting thing about running a program that is nationwide, and I'm sure many of you have experienced this in, you know, providing expert testimony in different courts across the country, is that there are vastly different approaches on the bench to the types of legal arguments that have more strength and can be kind of maneuvered in a different way to get people out of the particular social group framework. Just thinking off the top of my head, you know, in the courts in the Fourth Circuit, so the immigration courts in the DC area and Virginia, they are very amenable to granting asylum to individuals who have suffered gender-based violence on account of their imputed feminist political opinion or their actual feminist political opinion. So I think that's a really interesting approach that we should be taking in our expert reports, and trying to better contextualize the situation in country for women in particular who are abused by their domestic partners, and really framing that as more of a political opinion based claim. The other thing that we're likely to see is, again, a lot of attacks on the family-based social groups that we have been able to rely upon pretty consistently for many years, and that were also under attack during the Trump administration. I think as experts, it's really, as we're seeing additional changes that will come with the Trump administration, I encourage you to have very frank conversations with the attorneys that you're working with about what their legal approach is actually going to be in trying to frame the strongest possible asylum claim. So are they looking at at just a particular social group, and what is that? Are they looking at political opinion? Are they, is there some other fact that makes the client vulnerable that they're not even thinking about because they are not as attuned to the situation in country, such as, the person is actually, indigenous, and a lot of the harm that was suffered could likely be attributed to the person's ethnicity or race, and there might be another avenue there. So I think that those conversations are going to be much more, are really going to be critical with the Trump administration's new policies, and thinking through what are additional avenues, what alternative methods for arguing eligibility for asylum could exist outside of the particular social group framework. I'm not sure if there are any if there are any folks on the call here today that do medical or mental health related
Please speak to that, though.
Okay. So, obviously there are a number of things that those reports can be tremendously helpful for, including demonstrating past persecution and demonstrating the subjective fear, well-founded fear of future persecution. And so I think it's going to be really important to have a lot of those reports to demonstrate the mental health implications of any past harm, but also I think the mental health implications of ongoing harm that the individuals are going to be experiencing here in the United States at a time when, asylum seekers are being demonized and, accused of horrific things and told that they're not, worthy of protection, and the like. I think that mental health evaluations should include, ongoing harm that's happening while the individual is waiting for their case to be heard in the United States. And that because the trauma that they suffered in a home country they're continuing to be re-traumatized by the anti-immigrant sentiment here in the United States, that returning that person to their home country now at a point when they're constantly under attack would actually cause a more likely than not significant mental health harm if they were removed to their home country. The standard that we operate under in asylum proceedings is whether or not there's a 10% chance of persecution if they were to return to their home country. The standard for withholding of removal or CAT is a 50% or more, right? And so that 10% barrier is actually quite low. And so, the difference between someone having suffered past trauma, but having ongoing mental health issues while in the United States, while trying to seek asylum, might make it so that they are much more vulnerable and much more likely to suffer additional harm that would rise to the level of persecution, mental health harm included. And I think that that's something that can be relied upon and help adjudicators more comfortably make that determination that they would have a 1 in 10 chance of suffering persecution if they were returned to their home country. I think that, there's also going to be a lot of need for experts in the mental health field and in the medical field with regards to trying to get individuals out of detention. We're looking at a situation where there will likely be, mass enforcement actions and attempted mass deportations. In being able to have experts that can actually do those evaluations, and specifically that can go into detention facilities, which is a very burdensome process and does take quite a bit of maneuvering to actually get access to those facilities. But I do think that that identifying any potential mental health or medical issues could likely get people released on parole much more easily and prevent their, expedited processing and ultimately their deportation. So there's some really good kind of interventions that could happen at that stage that could help to slow down the deportation machine. But again, it's a very challenging process to actually get approval to gain access to those facilities. So it's certainly not for the weary, but that's something that can really be helpful moving forward and trying to prevent all of these mass enforcement efforts that are likely to take place.
Is
I'm
there a
trying to
role
think. Sure.
for experts in what I think might be the most dangerous new development, which is the kind of mass deportation, knocking on the door at 3 a.m. scenario, whatever it is that could be actually used for experts. In other words, I've heard publicly that the Trump administration is planning to say, if you can't prove that you've been here for 2 years, you're going to be removed immediately. What does that mean? What does that, excuse me, what does that look like in practice, and what role can independent experts play so much at the front end of this process, where we usually come in defensive proceedings more than even a credible hearings or early stage things? And if there's going to be mass removal of up to, who knows what the number's going to really be, but 10 million or more undocumented people in the United States who can't prove that they've been here for 2 years or less, or even if you've been here 50 years, what is our role in this process?
Yeah, I mean, you're correct about this. Individuals can be subject to expedited removal if they have been in the United States for less than 2 years, right? And so we are telling our clients to make sure that they are equipped with, documentation that shows, when their entry date was, if they have that, and, any other proof that they have, medical records, other things, school records of children and things of that like, to try to demonstrate that they actually have been in the United States for up to 2 years or for over 2 years. The consequence of that is if they can't prove that, they can be placed in expedited removal proceedings. And ultimately, they could be in a situation where they might not be able to obtain a credible fear interview to then place them into asylum proceedings, right? So I think that what we're doing as lawyers is trying to remind people, one, of their rights in general, right? If someone comes knocking on the door, they don't necessarily have to answer the door, and just making sure that people are equipped with know their rights. Two, that they're equipped with the documentation that they need to help fight their case and to prove that they wouldn't be subject to expedited removal. But three, I think it's really incumbent upon people to start preparing their cases well in advance of that potential day where they might, be apprehended and subject to an enforcement action. In the credible fear interview context, it's oftentimes a very, very, very quick process. And there's very limited access for counsel. Things move at a very quick pace. There could be a role at that point for someone in their credible fear interview to submit an expert country conditions report, for instance, or a mental health report. The problem is that the timing is so quick that there's no way that you could do that unless you've already done it in advance. And so that's, I think, the role is to, many of you are so in high demand by immigration attorneys in general, but I think that working with folks ahead of expected deadlines. So knowing that, okay, yeah, you have a hearing maybe in 3 years, but I'm not going to wait those 3 years to have a draft report ready to go in the event that that person's going to have a credible fear interview in a week's time. That's incredibly helpful. I know also some of you, and I think some others that might have been on the call earlier, have worked with organizations like CGRS and others and have created kind of universal expert declarations. And that's incredibly helpful for advocates to have at the ready, even if it's not specific to your client, but having those kind of generalized reports is incredibly helpful. There are issues in the immigration court context about, DHS objections about not being able to cross-examine the witness and things like that. But I think in these urgent, quick moving processes like credible fear interviews and the like, those universal reports can be really, really helpful to have ready. From your perspective also, though, and from our perspective as immigration attorneys, you don't want something that's stale either. Like, so if you provide a report today and ultimately it doesn't get used for 3 years, there's probably going to be issues with that. We're going to come back to you and ask for updates. But I do think that having some of those things ready and available, either from the country conditions perspective in the credible fear interview, or the mental health evaluations in the context of attempting to be released on parole, would be really useful tools to have to help, again, slow down these processes.
Could I also ask you, for the benefit of a more general audience who might eventually come across this recording, could you just outline the announced plans of the Trump administration and those which you think are subject to legal intervention to at least inhibit or change the outcome, and those which pretty much are the new environment and have to be fought politically as opposed to legally?
So in terms of what we're expecting to come down the pipeline?
Yes.
Yeah, so there are a number of different things that we're expecting. We mentioned already the outline that they're intending to engage in mass enforcement efforts and mass deportations. We are expecting that they
Let me
will
just
likely
add one thing. I'm sorry. What is the legal explanation for a national emergency or national security exception that permits? Is that a very clearly defined legal term of art, or is this something that's going to evolve over time in ways that novelists would have a field day on?
Yeah, I think probably the latter more than the former. No, I mean, the Trump administration is claiming that the border crisis is a national security emergency, and therefore he has the authority under, the oh my gosh, the alien. I'm forgetting the name of it. Forgive me. But he's saying that he has the authority essentially to utilize the National Guard and other law enforcement agencies to
And the other
enact.
forms of the armed forces.
Yes. Yes. I don't actually think that that's something that has much of a legal base in it. We'll certainly see challenges to these efforts as they move forward, but that's the justification at the moment, that there's a national security issue caused by the border crisis, alleged border crisis, and that's going to be the justification for these kinds of efforts and mass enforcement actions. But in terms of what else we're expecting, we will likely see another effort, much like we saw during the first Trump administration, of likely Muslim bans, banning individuals of certain faiths from certain countries coming into the United States. We're expecting that we will see additional border enforcement efforts, building upon what the Biden administration has already put in place, to be honest with you. But we're also expecting that he's likely to bring back the migrant protection protocols, which, if you recall, that was the Remain in Mexico plan that essentially sent all asylum seekers back to Mexico to wait for their hearings on the Mexican side of the border. We are expecting, as I mentioned before, changes to the likely changes to the statute, the asylum statute, and possible elimination of a particular social group as a basis for asylum. We are seeing that they will likely prevent access to asylum for anyone who enters the United States not at a port of entry, and also potentially those who do enter at a port of entry. We are also likely seeing that they are going to halt all refugee resettlement. So there's a whole host of very, very restrictive policies that we're expecting to see. And, unfortunately, we don't quite have all of the tools that we had the last time around to prevent a number of these things from going into effect. The Supreme Court came out with a decision that essentially limits our ability to file class action lawsuits in a number of cases. And that was the tool that was largely used last time around to stop a number of these policies from going into effect. And obviously the Trump administration has done quite a lot, did quite a lot in the last time around to kind of stack the courts with people who are more ideologically aligned with the Trump administration. And so it's just more challenging in general, even in places where I am, which is the Ninth Circuit, which tends to have more favorable immigration related laws and decisions. It's even more challenging here.
That's San Francisco.
I'm in Los Angeles, but yeah.
I'm sorry. Okay.
Yeah.
How many of these policies could be executive regulations and decrees as opposed to requiring a law be passed by both?
Yeah.
houses?
So you can't change, for instance, the asylum statute without congressional action. So that's something that would require Congress to act, but
Even with the
unfortunately,
national emergency declared?
that can be done through executive order. There are also a number of different rules and regulations that can be promulgated through interim final rules, which is what the Trump administration did the last time around, and the Biden administration has done this time around as well. Those can go into effect immediately, and those can change things like what we've seen in the past and now about, for instance, the Safe Third Country Agreement, that if you've gone through another country en route to the United States, you must have sought asylum there and been denied in order to actually be able to seek asylum in the United States. We're likely to see that rule come back as well. And that's actually, if I can quickly divert back to that, that's another area that I think is really important for country conditions experts in particular. And it might be that we as lawyers need to have multiple experts for these kinds of situations, but essentially having an expert that can talk to not only the persecution that the person would suffer in home country, but also in any of the countries that they traveled through en route to the United States, will be more necessary moving forward than it has been in the past, just because we will likely see the need to prove that you would actually suffer persecution in multiple countries, and that was the reason why you weren't able to seek asylum there. So yeah, so we'll I think that you all will have no shortage of cases coming your way in terms of needing additional new creative legal arguments to be supported by factual country conditions, but also having to broaden the scope of those reports to not just include country of origin, but also countries of transit. I know you were mentioning earlier, your work on Haiti. We're seeing increasingly, issues with regards to Haitians who are transiting through Brazil, and I mean, not just Haitians, but people in general. And so I think that educating judges and trial attorneys through the use of expert reports is an incredibly effective tool, and will ultimately go a long way towards helping to protect the rights of those seeking asylum.
And one last question to you before we conclude today's marathon session. What can we do to, we have this seminar, and it's a recruitment device as well as an educational device, but what can we do to get more people involved as independent expert witnesses? Is there anything other than just common sense, word of mouth, advertising that you can think of? Can we educate law firms to sponsor more of this work or involve in seminars?
Yeah, I think certainly partnering with law firms is a great idea. But I think when I think about one of the barriers that I imagine exists to providing these expert reports is that people just are a little bit intimidated by the process. They don't, if they're not properly trained, if they don't have really good templates to help them understand what an effective report looks like, and if they're also not equipped to understand what it will be like if they are ultimately required to testify in court, and what that whole qualification process looks like, it can be really daunting. So I think that just having more training and educational materials for experts, and maybe even some sort of a mentorship kind of pathway to help people understand what's going to be effective. What are the common issues? I mean, I was looking at your agenda for today, and I actually wish I could have joined the whole day, but it was short notice, and I had other meetings on my schedule. But you know, you're ticking all the boxes that I would want an expert to be talking about and thinking about. So I think more things like this would be incredibly helpful to get folks on board. I will also say, you know, there was a mention earlier about kind of the economics of it, of like what you charge and to whom and everything. And I'm being very selfish here, but like as someone who runs a pro bono program, you know, we work with a lot of experts, but we're also recommending that our pro bonos work with a lot of experts across the board. And so, you know, I might be cheeky and ask for a pro bono expert report, but I'm saying it knowing that I'm going to then refer you to 10 law firms down the road, and you know, you're going to be able to you know, make some money and sustain your work through that. So I do think that having good relationships with the pro bono organizations that are doing the work, that work with then individuals at law firms that are going to be able to help you know, compensate you for this is a good strategy to get people excited about the financial viability of
For most of
doing
us,
this really challenging
more
work.
pro bono, but I guess that's a financial inducement would recruit more people.
Yeah. But I do think that like having more templates, having more trainings, and again, you know, providing some mentorship for people who maybe haven't done it before, letting them speak to another another expert, so that they can kind of see what their experience has been like, and what the reports are going to look like, what the pitfalls might be, what things to avoid. We obviously try to equip our experts to the best that we can to and review those reports and make sure that they're going to overcome any potential challenges. But you know, you all know just as well, you know, you're the ones that are undergoing cross-examination and direct examination. And so having more tools that you can share with others, I think would be a way of eliminating some of the barriers to engaging in pro bono expert reports.
Thank you so much, Janet, and to Human Rights Watch. First, excuse me. I'm sure not the first person
You know,
to say that.
can I
Yes,
just
go
put
ahead, Ron.
a brief note? I think this is an important point, because all of us go into academia wanting to use our work to help the world, and academic careers pull you further and further away from that. So I think one of the things that I've tried to do, I know Cecilia Menjivar at UCLA has done this. We've done training several times on being an expert at the American Sociological Association meetings, but I also think there's a very important role for academic centers to do this kind of preparation and training. And I think it's like, you know, I mean, we're all doing one-offs, right? This is a one-off. If there was like
Actually, this is my third ISA seminar, and Tom and I work together at LASA as well.
I've done several of them. And I'm not criticizing. I think you're adding, and this is valuable and important, but it's not the same thing as a sustained institutionalized commitment by an institution where somebody's paid to run and coordinate and do the kind of work that links the experts up, right? The key thing about the use of research in applied settings is not the quality of the research, it's the quality of the links between the researcher and the end user. And for all of us as professors to be creating that in addition to doing all the other stuff, it's just because we really want to do this work. But there should be, I have argued for this and tried to set this up, universities should also be committing resources, and there should be centers that are working on this kind of applied work, because that's one of the reasons our work is meaningless in much of the world, right? And people complain about
maybe
this.
we need to connect with law schools and not arts and sciences faculty, because
Well,
they're the ones that have the
I
clout.
think both things, working with law clinics, working with like, Berkeley has an expert registry, but I think that more, given what we all expect we're going to see, the time might be right for us to attempt to create that kind of infrastructure, or at least say, come on, just throw us a bone, give us 2 years of funding to do the minimal thing and see how much help we can generate with this. Because people want to do things, but then they don't know where to go to fight or how to do it. So
because universities are so territorial that they don't want to collaborate, but actually inter-university collaboration and cooperation could be a dynamic kind of network, if not an organization.
I think you're
Even within
overthinking
one
that. I just
specific
want, like, give me the
university.
funding. Like, just give me a promise, right? Give me one guy for 2 years or something like that. I'm joking about overthinking it, but I think, Jenna, you were going to respond.
Yeah, I think, even if you're talking on a little bit of a smaller scale, even within one individual university, if that university has both a law school and it has, a school of arts and sciences that where you can be partnering, where the law school probably has an immigration clinic, right? And there should be people within the university that might be able to provide those expert reports that would be working in conjunction with the law school and the clinic on those efforts. But I do agree that I think that this is the moment. People are feeling very inspired to act. And this would be the type of moment to, when people are asking the questions of like, how can we help? What can we do? Well, this is exactly it. You come from an academic background that has a very specific set of expertise and can be really impactful in these asylum cases. You're maybe not representing the individuals yourselves, but this is a huge added value to these cases, and it might be a good moment to propose that kind of a coordinated pro bono effort, and there might be funding for that in this specific moment.
And maybe we could go to non-traditional sources of funding for us. I mean, corporations, for example, which might donate in corporate charity and corporate philanthropy to the local museum, but they might also feel like, gee, our workforce in this city is highly dependent on migrants. The price of food will go up for the country if we deport agricultural workers, but it also refers to manufacturing and other realms. So I want to thank the three of you who are still with us, Tom, Jenna, and Rob, and all of our previous presenters today who've been so generous with their time. Sarah preceding, Lisa Knauer, and Mark Unger, Denise, retired Judge Denise Slavin, and Alexis Ruiz of Zambrano and Ruiz, Michelle Devereaux from the Africa Advocacy Network in San Francisco, and Monica Kant, formerly the director of the Georgia Asylum and Immigration Network here in Atlanta. And to our helpers from ISA, many of them have been here for this whole marathon, Hannah, Joel, and Kat, as well as others who've worked behind the scene at ISA for sponsoring this. And I really, really hope we can look at this next stage as an opportunity, as not an obstacle. So thanks everybody for attending. And if anybody else has a final word, we'll just say goodbye and keep on trucking.
Thanks for organizing. And I have to say, I've been a little inspired by everybody here, given the generally grim mood that I've been in for the last 3 weeks. I do appreciate the creative thinking about what we might be able to do. Thank you.
And thank you, Rob, for your suggestion at the end, and to Jenna and to Tom, as always. Take good care, everybody, and goodbye to our audience as well.
Thanks again, Chip, for pulling this together.
Sure. I got to interact with old friends, so it's great. Thank you.
Thank you.
Take care, everybody.